Statutes. Short answers. Meaning of literal, grammatical, plain, natural, ordinary, and popular rule. Its strengths and weaknesses. Meaning. Grammatical, literal rule of interpretation is the primary rule of interpretation. The first interpretation is literal or grammatical interpretation. The epithets natural, literal, grammatical, and popular are employed almost interchangeably. Literal rule is where the judges interpret the legislation that the parliament has passed. Here the judges rely on the exact wording of the statute for the case. They don't interpret the meaning. Grammatical interpretation is an elementary principle of interpretation, and the plain intention of the legislature as expressed by the language employed is to be accepted and given effect to. In case of grammatical interpretation, only the verbal expression of law is taken into consideration, and the courts do not go beyond what is expressed by words. The dictate of words is known as litera legis. The grammatical or literal interpretation and construction is totally confined to the words or expressions used in the language of the statute. It does not look beyond what has been stated. The consequence is no consideration. It remains firm on the letter of law, even if injustice or hardship is caused. Definition of literal rule. Brett M.R. called the literal rule as a cardinal rule that wherever you have to construe a statute or a document, you do not construe it according to the mere ordinary general meaning of the words, but according to the ordinary meaning of the words as applied to the subject matter with regard to which they are used. Generally, the courts must take it for granted that what legislature has said, courts have no liberty to add or take from or modify the letter of the law. Viscount Simon says the natural and ordinary meaning of words should not be departed from unless it can be shown that the legal context in which words are used requires a different meaning. The term grammatical construction was used by Salmon. He explains, interpretation is of two kinds which may be distinguished as literal and functional. The literal interpretation is that with regard to exclusively the expression of law. It does not look beyond the literal letter of law. Functional interpretation, on the other hand, is that which departs from the letter of law and seeks elsewhere for some other or more satisfactory evidence of the true intention of the legislature. It is essential to determine with accuracy the relation which subsists between these two methods. In other words, we have to determine the relative claims of the letter and spirit, legislative intent and object of statute of enacted law. 8 rules of grammatical or literal rule. Under grammatical literal rule, the judge considers what the statute actually says rather than what it might mean. The following 8 rules are at the heart or center of the grammatical interpretation. Define the terms words being considered and then adhere to the defined meanings. Do not add meaning to established words or terms. What was the common usage in the culture and time period when the passage was written? Avoid using words or phrases out of context. The context must define terms and how words are used. Do not separate interpretation and historical investigation. Be certain that words as interpreted agree with the overall premise. Use the known and commonly accepted meanings of words, not obscure meanings for which there are no precedents. Even though many documents may be used there must be general unity among them. Base conclusions on what is already known and established, or can be reasonably from all known facts. Where the meaning of the statutory word is plain and unambiguous, it is not then that for the judges to invent fancied ambiguities and excuse or failing which to give effect to its plain meaning, because they consider the consequences for doing so would be expedient, not advantageous, or even unjust or immoral. Examples of grammatical or literal rule. Fisher versus Bell. Under the Restrictive of Offensive Weapons Act 1959, it is an offence to offer for sale certain offensive weapons including flick knives. James Bell, a Bristol shopkeeper, displayed a weapon of this type in his shop window in the arcade in Broadmead. The divisional court held that he could not be convicted because giving words in the statute a literal meaning. Bell had not offered the knives for sale. In the law of contracts, placing something in a shop window is not technically an offer for sale. It is merely an invitation to offer. It is the customer who makes an offer to the shopkeeper. Orr versus Harris, where the defendant bit the nose of the victim. The statute stated the offence was to stab or wound. Under the literal rule, biting is neither stabbing nor cutting nor wounding, implying an use of instrument. The defendant was proven not guilty. Advantages of literal or grammatical rule. When the literal rule is applied, there is no scope for judges' own opinion or prejudices to interfere. The literal rule respects parliamentary supremacy and upholds the separation of power. The literal rule encourages drafting precision, promotes certainty, and reduces litigation. Disadvantages of literal rule. The grammatical rule fails to recognize that English language itself is ambiguous. The words may have different meanings in different contexts. Use of grammatical rule can sometimes lead to absurdities and loopholes which can be exploited by unmeritorious litigant. Judges have tended to overemphasize the literal meaning of statutory provisions without giving due weight to their meaning in a wider context. Emphasizing the literal meaning of words assumes an unobtainable perfection in draftsmanship. It ignores the limitation of language. Sometimes application of the literal rule may lead to injustice. In London North Eastern Railway Company versus Berryman, a railway worker was killed whilst oiling a track. Under the statute, compensation is provided on the death of the worker replacing or relaying a track. The statute did not cover oiling and so compensation was not given. This can undermine public confidence in case laws in India. In KN Farm Industries Private Limited versus State of Bihar, AER 2009, the meaning of the word land was in question. Land under Section 2F Bihar Land Reform Fixation of Ceiling Area and Acquisition of Surplus Land Act 1961 as applicable to the state of Jharkhand means land which is used or capable of being used for agriculture or horticulture and includes land which is an orchard, carcour or pasturage or forest land or even land perennially submerged under water or homestead of a landholder. Homestead means a dwelling house for the purpose of living or to let out on rent together with any courtyard, compound, attached garden, orchard, outbuilding includes any outbuilding for the purpose connected with agriculture or horticulture or any tank, library and place of worship appertaining to such dwelling house. Explanation 11. Land perennially submerged under water shall not include submerged in the bed of a river. Supreme Court held that if a tank appertaining to a dwelling house is land, it follows that any tank appertaining to agricultural horticultural land is used to irrigate or water such agricultural horticultural land will also be land. When the tank is specifically referred to as land in Explanation 1 in the definition of land section 2F, it is not possible to accept the contention that no tank can be land. Thus, it is not possible to exclude land perennially covered with water, which includes the tanks from the definition of land. In essay Venkatraman versus Union of India, an inquiry has been made against the appellant under Public Services Inquiries Act. On receiving the report of the Inquiry Commissioner, appellant was given an opportunity under Article 311, Clause 2 of the Constitution to show cause and was ultimately dismissed. Later on, he was charged under Section 161, 165 Indian Penal Code, Section 5, Clause 2, Prevention of Corruption Act 1947 on the question whether his trial violated Article 20, Clause 2 of the Constitution. Supreme Court held that proceeding before the Commissioner was not prosecution, a judicial process. Therefore, his trial was legal. Harmonious construction. The rule of harmonious construction plays a significant role in interpreting two or more statutes or two or more parts of a statute when they conflict with each other. It follows a very simple rule that every statute has a purpose and the intent as per law and should be read as a whole. It is the duty of the courts to avoid a friend or a foe or a head-on clash between the two sections of the same act, and whenever it is possible to do so, to construe provisions which appear to conflict possible so that they harmonize. The rule of harmonious construction is the thumb rule to the interpretation of any statute. An interpretation which makes the enactment a consistent whole should be the aim of the courts, and construction which avoids inconsistency or repugnancy between the various sections or parts of the statute should be adopted. The court should avoid a head-on clash, in the words of the Apex Court, between the different parts of enactment, and conflict between the various provisions should be sought to be harmonized. The normal presumption should be consistency, and it should not be assumed that what is given with one hand by the legislature is sought to be taken away by the other. The rule of harmonious construction has been tersely explained by the Supreme Court thus: when there are in an enactment two provisos which cannot be reconciled with each other, they should be so interpreted that if possible the effect should be given to both. A construction which makes one portion of the enactment a dead letter should be avoided, since harmonization is not equivalent to destruction. Harmonious construction should be applied to statutory rules, and courts should avoid absurd or unintended results. It should be resorted to making the provision meaningful in the context. It should be in consonance, that is, agreement or harmony, with the intention of rule makers. Rule of harmonious construction is applicable to subordinate legislature also. As stated by Venkatrama Iyer J., the rule of construction is well settled that when there are in an enactment two provisions which cannot be reconciled with each other, they should be so interpreted that if possible the effect should be given to both. That is what is known as the rule of harmonious construction. The effect should be given to both is the very essence of the rule. Thus, a construction that reduces one of the provisions to a useless lumber, that is disused or cumbersome, or a dead letter, is not harmonious. To harmonize is not to destroy. It is a settled rule that an interpretation which results in hardship, injustice, inconvenience, or anomaly should be avoided, and that which supports the sense of justice should be adopted. The court leans in favor of an interpretation which conforms to justice and fair play and prevents injustice. On a summary of the case law, the following principles are discernible, noticeable. 1. It is the duty of the courts to avoid a head-on clash between two sections of the Act and to construe the provisions which appear to be in conflict with each other in such a manner as to harmonize them. The provision of one section cannot be used to defeat the provision contained in another unless the court, despite all its effort, is unable to find a way to reconcile the differences. When it is impossible to completely reconcile the differences in contradictory provisions, the courts must interpret them in such a way so that effect is given to both the provisions as much as possible. Courts must also keep in mind that interpretation that reduces one provision to a useless number or a dead lumber is not a harmonious construction. To harmonize is not to destroy any statutory provision or to render it otiotize, serving no practical purpose or a result, that is OTOs. Cases. In Bengal Immunity Company versus State of Bihar, the question of solving the conflict between Article 286 Clause 1, explanation as it then stood, to Article 286 Clause 1, Subclause A, and Article 286 Clause 2 was before the court. Article 286 Clause 1 said, no law of the state shall impose a tax on the sale of goods where such sale takes place outside the state. The explanation to Article 286 Clause 1A stated, for the purpose of Subclause A, a sale should. The respondent argued that they were entitled to tax the sales made by the appellant, a registered dealer under the Bengal Financial Tax Act, in the course of interstate trade or commerce, because the goods had been delivered in the respondent state for consumption in that state. Applying the principle of harmonious construction, the Supreme Court held that the conflict between the said provisions could be solved if the explanation to Article 286 Clause 1, Clause A was interpreted as limited only to 286 Clause 1A, because the only purpose of the explanation was to explain the meaning of the phrase outside sale used in Article 286 1A. The explanation, therefore, could not be extended to Article 286 Clause 2 either as an exception or as a proviso thereto. Venkatrama Iyer, in his minority opinion, stated it is a cardinal rule of construction that when there is in a statute two provisions which are in conflict with each other, so that both of them cannot stand, they should, if possible, be so interpreted that effect can be given to both, and that construction which renders either of them inoperative and useless should not be adopted except in that last resort. In the case D. Sanjeevaya versus Election Tribunal, the election of the appellant to the State Legislative Assembly was challenged by the petitioner, who prayed that he be declared elected in place of the appellant. During the pendency of this petition, the appellant got elected to the Rajya Sabha and so resigned from Assembly. He filed a writ petition in the High Court with the prayer of a direction to be issued to the Election Commissioner for proceeding with the holding of a by-election of the seat vacated by him under Section 150 of Representation of People Act 1951. High Court dismissed his petition. Supreme Court, agreeing with the decision of the High Court, held that Section 150 could not be interpreted in isolation because Court had to keep in mind the other related provisions in the Act, such as Section 84 and 98C. If the appellant's argument that the Election Commissioner should start making arrangements for by-election immediately after the resignation of a member, even though election petition against the member is pending or accepted, the effect of it could lead to an absurdity never intended by the Parliament. Such will be the case that where, for instance, the election petitioner wins his petition against the member vacating his seat and is declared elected, in such a situation there will be two persons representing the same constituency, which could never have been the will of the legislature. Construing 150 harmoniously with Section 84 and 98C, therefore, will lead to the conclusion that while enacting Section 150, Parliament did not intend that the petition should stand dismissed with the resignation of the member against whom the petition has been brought. Next, interpretation or definition clauses. Answer. The legislation can lay down legal definition of its own language if such bodies are embodied in the code itself. It becomes binding on the courts. When the Act itself provides a dictionary for the words used, the court must first look into that dictionary for interpretation. In the case Mayor of Portsmouth versus Smith, the court said that the introduction of the interpretation clause is a novelty. There have been both the criticism and the appraisal made in reference to the inclusion of the definition clause in a statute. In Mayor of Portsmouth versus Smith, the court observed, the introduction of interpretation clause is a novelty. When the Act itself provides the dictionary for the words used, the court must first look into that dictionary for interpretation. And then there has been a criticism made as to the utility of definition clause or the interpretation clause. Despite this, there has been an inclusion of definition clause in most of the statutes so created, whether the Indian statutes or the statutes abroad. Talking of the pros of adding definitions to a statute, these definitions help greatly to the one who reads the statute. Following are the benefits that arise by adding meaning to the frequent and important words of a statute. It provides some kind of certainty and an idea as to what extent is the meaning of the phrase or a word so defined can be taken. Without having any definition to a word, it becomes ambiguous as to what the statute or legislature had the intention of the word so added. When a word has been defined in a statute, it saves the same word to be defined everywhere in a statute, since the words so defined are frequently used. It is a great help to those reading and making in use the statutes. By adding definition to a word, it is helpful as one can easily understand as to what the statute is intended to say. A statute thus may well provide with the definition of a word which suits the legislation and can differ with the general meaning of the word and yet still stand authoritative. There are different meanings to a word when used as different dictionaries provide with quite different meanings, hindering the interpretation of a word and thus the provision in a statute. Providing with a definition in the statute itself makes it a lot easier to understand what was the word in the statute really means and would help interpret further on if need be, thus eliminating the ambiguity as to the meaning of the word or a phrase in a statute. As to the cons of adding meaning or a definition to a word in legislation, there has been a criticism made on it. On drawing a balance between them while comparing both the pros and cons of adding a definition clause to a statute, it seems the pros have a higher persuasive value of adding meaning to a statute than the cons of it. To sum up, the object of a definition is to avoid the necessity of frequent repetitions in describing the subject matter to which the word or expression defined is intended to apply. A definition contained in the definition clause of a particular statute should be used for the purpose of that act. Definition from any other statute cannot be borrowed and used ignoring the definition contained in the statute itself. Restrictive definitions. As stated above, a statute may define a word even artificially, setting up out of its ambit whether to make restrictive of a definition or to make it extensive. When a word is defined to mean something, the definition prima facie is restrictive in nature and is exhaustive. A restrictive definition means that the meaning so defined in the statute for a particular word has a very restrictive ambit, so much so that the meaning cannot go beyond what has been defined. There is nothing that can be included in the meaning beyond what has been stated. There is seldom any scope for interpretation in case of restrictive definition. Where means is employed, it shows that the definition enacted is hard and fast, and that no other meaning can be assigned to the word defined, that is put down in the definition. Where in the definition clause given in any statute the word means is used, what follows is intended to speak exhaustively. When the word means is used in the definition, it is hard and fast definition, and no meaning other than that which is put in the definition can be assigned to the same. Extensive definition. When the word defined contains include in the meaning, the definition is extensive in nature. In case of an extensive definition, the definition of the word has been scope and ambit to go beyond what has been stated, and it also gives the scope to interpret and incorporate as to what all can be included in the definition. If a word is to mean one thing and include other things as well, then it does not mean that the former thing will also be included in the meaning along with the latter things. The word include is very generally used in the interpretation clause in order to enlarge the meaning of words and phrases occurring in the body of the statute, and when it is so used, those words or phrases must be construed as comprehending not only such things as they signify according to their natural import, but also those things which the interpretation clause declares that they shall include. In the case State of Maharashtra versus Labour Law Practitioner Association, the court gave the word district judge under Article 236A of the Constitution an extensive definition, saying that the word would include the hierarchy of specialized civil courts, namely labour courts and industrial courts, which are not expressly included in the definition. But the word include is susceptible of another construction, which may become imperative if the context of the act is sufficient to show that it was not merely employed for the purpose of adding the natural significance of the words or expressions used. This may be equivalent to mean and include, and for the purpose of the act must invariably be attached to those words and expressions. Thus, word include may sometimes be used in the context of a mean and would thus limit or bar further inclusion of other things into the meaning of the word or the phrase of the act. The word include may in exceptional cases be construed as equivalent to mean and include. A definition section may also be written as is deemed to include, which again is an inclusive or extensive definition, and such a form is used to bring in by a legal fiction something within the word defined which according to its ordinary meaning is not included within it. Wherein a definition by way of amendment replaced mean by include, it is construed to give a wider meaning and perspective to the definition, and that the earlier definition, which was limited and restricted to the meaning so defined, and to such things defined, would no longer be applicable. Exhaustive definition. A definition using mean and include is considered as exhaustive. This means that the definition will embrace only what is compared with the ordinary meaning of the means, together with what is mentioned in includes part of the definition. Thus, a definition may both mean and include, wherein one thing would mean such and such a thing, and others would include things more than what is stated. Thus, it can include and exclude both in the sense that at one place in the definition it can include things, at the other place of the same definition it can exclude other things to be incorporated. The definition of transfer of property under Gift Tax Act 1958 came into jeopardy as the words disposition, conveyance, assignment, settlement, delivery, and payment were used in the definition, which signifies different modes of transfer of property. Here it was construed that the partition of a Hindu undivided family would not be included in the definition, as the meaning cannot be extended to a transfer of property where there is no tax applied. Ambiguous definitions. There are definitions that are ambiguous in itself. This happens when the definition itself is not clear as to its scope and meaning, and there requires further interpretation of those words or phrases in order to understand or make it applicable to a certain case. It is presumed that the definition given by the legislature in the statute will have an effect to the extent that there might not be any requirement to interpret the word further on, and that the meaning so provided would be sufficient in itself. Yet there are definitions that the legislature makes which are ambiguous and require further interpretation. It must be read in the context of the phrase which it defines, realizing that the function of a definition is to give precision and certainty to a word or phrase which would otherwise be vague and uncertain, but not to contradict it or supplant it altogether. Thus, in a case a definition clause is ambiguous and does not provide with a sufficient meaning, there requires interpretation to the word in a sense that it should apply to the case. Also, in order to understand and complete the meaning of a word, it should not be read in isolation and should require taking the help of other provisions or the definitions for the same word provided in different statutes. This in turn provides rather a specific and precise meaning to the word so defined in ambiguity, and helps in understanding, applying it to the relevant situation and to situation wherever necessary. For example, the phrase immovable property has nowhere been defined in exhaustive sense that it is sufficient to not look anywhere else in order to understand the meaning of the phrase. Thus, the immovable property has been defined under three provisions in three different statutes. They are Transfer of Property Act, General Clauses Act, and Registration Act. Section 3 Transfer of Property Act. Immovable property does not include standing timber, growing crops, or grass. Section 3 Clause 26 General Clauses Act. Immovable property shall include land, benefits to arise out of land, and things attached to earth or permanently fastened to anything attached to earth. Section 2 Clause 6 Registration Act 1908. Immovable property includes land, buildings, hereditary allowances, right of ways, lights, ferries, fisheries, or any other benefit to arise out of land, and things attached to earth or permanently fastened to anything which is attached to earth but not standing timber, growing crops, or grass. In this, the definition given in the Transfer of Property Act is not sufficient, and help of the other two provisions from General Clauses Act and Registration Act is taken, which provides somehow a broader perspective and meaning to the phrase. The definitions themselves cannot provide with an exhaustive meaning, and hence there requires interpretation of the provisions. Wide words used in interpretation clause may thus be given a limited meaning having regard to the context as a whole for a word in a statute, whether it be in the body of the statute or in the interpretation clause. He is not to be construed without reference to the context in which appears. However, it will not be correct to say that a wide word in an inclusive definition should be given a limited scope by reference merely to the ordinary meaning of the word defined. Definitions when subject to contrary extent. In context to the definitions of this kind, Lord Dunedin said, "It is novel and unheard of." The idea that an interpretation clause which might easily be so expressed as to cover certain sections and not cover others should be, when expressed in general terms, divided up by sort of theory applicana singula singulis, so as not to apply to sections which are context suggests no difficulty of application. If the legislature defines a term in the absence of a clear indication to the contrary, Those terms shall be used as proposed, but where there is a context otherwise required, the terms or words shall be given a meaning different from that defined in the statute, and thus comes into play the part of the interpretation. The definitions many times contain phrases like unless the context otherwise requires, or unless there is anything repugnant in the subject or a context. In these situations, a contrary context may be used for the purpose of the situation in the case, and even if it has not been expressly stated in the definition, it is imperative to make the interpretation of the words so used if so required. An argument based on contrary context which will make the inclusive definition inapplicable to any provision in the Act cannot be accepted, as it would make the definition entirely useless. When the application of the definition of a term in a provision containing that the term makes it unworkable and otiose, serving no practical purpose, it can be said that the definition does not apply to that provision because of the contrary context. While finding the meaning of the word insurer in various sections of the Act, Insurance Act, the meaning to be ordinarily given to it is that given in the definition clause. But this is flexible, and there may be sections in the Act which mean where the meaning may have to be departed from on account of the subject or context in which the word has been used, and that will give effect to opening sentence of the definition. The definition of the word shall also be amended if there is a change made in the provisions of the Constitution and the Act, and both do not cohere with each other due to the definition. If there is an amendment made in the Constitution or an Act or both, due to which some provisions do not have conformity with each other, which include the usage of the meanings of the words which remain unamended, the words so defined are useless and redundant. Similarly, in construing the word workman, section 33C2 of the Industrial Dispute Act 1947, it was held that the word included a dismissed workman, although in the definition of that word as given in section 2, a dismissed workman is included only for the purpose of industrial dispute in section 10. The court not only has to look at the words but the context, the co-allocation, and the object in order to interpret the meaning to relate the word. Conclusion. The definition clause so added in an act provides with a lot of help in determining the meaning of a word in a statute, whereas it becomes cumbersome to find the correct contention of a word used in a statute. The inclusion of definition or interpretation clause becomes helpful by providing the required context or meaning of the word so used in a statute either once or several times. Consequences of repeal. Effect of repeal. In general, the term repeal stands for to cancel or to revoke, but in the context of law, it means to abolish statutes. Repeal of statutes means the abolition of the law, and once if any statute is abolished, then it is considered void and possesses no effects. In addition, there is no basic difference between amendment and repeal. Both the term amendment and repeal is used for stating a similar expression, that is substitution or omission or addition. As per Halsbury Laws of England, the term repeal stands for revoking or abolishing an act and all its effect which cause it cease to be a part of the statute of books or body of law. According to Black's Law Dictionary, the term repeal means a legislative act which abrogates and obliterates an existing statute. There exist two types of statutes, temporary and perpetual. Temporary statutes tend to have effect for a specific period of time. They have no effect after the expiry of the specific period. However, permanent or the perpetual statute is one which the statute remains effective until it is substituted or repealed by a legislative act later. The power to repeal a statute is conferred to the legislature similar to the powers it has for enactment of a statute. The Companies Act 2013 repealed the Companies Act 1956, CRPC 1973 repealed previous Criminal Procedure Code. Such power of repealing a statute is similar and coextensive to the power of making or enacting a law. Both the union and state legislature are empowered with such power. However, they are restricted to delegate the power of repealing. What are the objects of repealing act? The primary object of this act is to bring necessary changes in the existing law for changing socio-economic and cultural conditions from time to time. The purpose of this act is to remove the outdated or obsolete matter from the body of law. After the removal of obsolete matter, it is a court that decides whether the new provision meets the goal and has different intentions or not. This act is the editorial revision by abolishing obsolete or unnecessary matter of the statute and adding new and proper information in the books of the statute. What are the kinds of repeal? There are two types of repeal: express repeal, implied repeal. Express repeal. Express repeal is an expression which means the abolition of previously enacted statute by the newly enacted provisions of a statute through expressed words embedded under the new statute enacted. The statute which has been repealed is called the repealed statute. The one which replaces the earlier statute is called the repealing statute. In general, when an earlier statute or some of its provisions are repealed through express words embedded under the newly enacted statute, stating that the provisions are now of no effect is called the express repeal. What are the essential features that constitute express repeal? The first and foremost feature is that there must be a repealing statute. The earlier statute must be repealed by the new enacting or repealing statute. Enacted statute must have clear intention showing the effect of the repeal. So it is understood that any earlier statute or provision of the statute can be removed or repealed by the enacted statute showing incompatibility with the previous one. Implied repeal. The term implied means implicit or hinted. So when a statute becomes obsolete and it is inferred that it is no longer and shall be repealed with the newly enacted statute, then this process of repealing is called implied repeal. For example, if we enter a car showroom, it is intended that we are there to buy the car. It is implied. Similarly, if there arises any inconsistency in the statute and due to certain circumstances it becomes necessary to repeal the statute with the new one, though such situation is not expressly stated, then it is implicit for the implication of repeal. When the reference is not direct, then the matter is decided through the meaning and nature of the words enshrined under the repeal clause. During the absence of provisions relating to express repeal, the continuance of any statute or legislation is presumed. In the case of implied repeal, the burden lies over the person who asserted the implication of repeal. However, it has also been mentioned that if the newly elected statute shows no clear intention or is inconsistent with the provisions of the earlier act, then such an assertion or presumption is rebutted, and the act of repeal is done by the inferring necessary implications. The concept of implied repeal is loosely based on the following maxim: legis posterioris prioris contrarias abrogant. This means the earlier or previously enacted law shall be obliterated or abolished by a new law. Under the following circumstances, the implied repeal is inferred. The first circumstance is when both the subsequent and earlier enacted acts are inconsistent with each other. One of the two can remain effective. When the subject of the earlier act is covered by the act and is the test of the implied repeal, there is an assertion against the repeal by implication. The reason for making such an assertion is that legislature, while making or enacting the law, has full knowledge about the current laws on the subject matter. If the legislature has no provision regarding repeal of the statute, then it is asserted that the legislature has no intention to repeal the existing statute. Municipal Council Palari versus T.J. Joseph. In the instant case, it was held that if an act or a provision enacted is inconsistent from the act previously enacted and one of the acts must be obliterated, the presumption in this case is rebutted and the implied repeal is inferred. For the implied repeal of a statute, following points are to be considered: whether the previously enacted laws are in direct contradiction to the later enacted laws, the conflict between the laws is of such nature and that can't be resolved, and reconciliation between the laws is not possible, whether the newly elected act is not consistent with the previously enacted act and one has to be obliterated, when both the laws are of such a nature that occupy and deal with the same field. Case Delhi Municipality versus Shiv Shankar. In the instant case, it was held at the Supreme Court of India that the text which is applied in case of repugnancy under Article 254 of the Indian Constitution, while resolving the conflicts arising between the laws enacted by the Parliament and the laws created by the state legislature. This test of determining repugnancy shall be applied in case of implied repeal of a statute. The test includes whether there exists a direct contradiction between two statutes or provisions, whether the law tends to occupy the same field, where the legislature explicitly focused on the code of the particular subject, whether subject matter replacing the earlier law. Case Ratanlal Adukia versus Union of India. In the instant case, Supreme Court stated that the doctrine of implied repeal is loosely based on the statement that the legislature assumed the current state of the law did not intend to generate any vagueness by retaining the conflicting provisions. The court, while implicating this doctrine, examines the nature and scope of two enactments by giving effect to the legislative intent. Case Damji versus LIC. In the instant case, it was held that Section 446, embedded under the Companies Act 1956, is a general provision, whereas the Section 15 and 41, enshrined under the LIC Act 1956, are special provisions. So there exists a difference, and the company's court is not competent or have jurisdiction over the matters which fall under the ambit of Insurance Corporation Act 1956. What do you mean by repeal by desuetude? As it has been already stated, there are two types of statutes, namely temporary statute and permanent statute. There exists a very thin line difference between both the statutes. A temporary statute is enacted for specific purposes and for a specific time period and gets repealed after the expiry of that particular period or fulfillment for that purpose. A permanent statute is also known as a perpetual statute, is enacted with a long-term goal and gets repealed by the subsequent statute. There are certain acts which possess the nature of a permanent statute but remain inoperative and ineffective for a long period of time, as they are not applied or taken into consideration by the court for a long period of time. Due to this, the statute loses its recognition and its applicability. Such a disobedience of act is known as repeal by desuetude. There are certain acts which possess the nature of permanent statute but remain inoperative and ineffective for a long period of time, as they are not applied or taken into consideration by the court for a long period of time. Due to this, the statute loses its recognition and its applicability. Such a disobedience of an act is known as repeal by desuetude. The Municipal Corporation for the City of Pune and another versus Bharat Forge Company Limited. In the instant case, the following doctrine of desuetude was highly criticized as it was assumed that the perpetrators or the accused who have committed certain crimes and are punished for violation of certain laws or statute which has become ineffective can be protected and escape their criminal liability. What are the effects or consequences of repeal? The effect of repeal of a statute has been described under the following heads: in respect of common law, in general, effect of repeal, and General Clause Act 1897. Effect or repeal with respect to common law. Obliteration. Except as to the transactions past and closed, a statute after its repeal is as completely as if it had never been enacted. Depriving the rights. The effect is to destroy all inchoate rights and all causes of action that may have arisen under the repealed statute. Revival. Another result of the repeal under common law rule is to revive the law in force at the commencement of the repealed statute. Thus, if one statute is repealed by a second statute, which in turn is repealed by a third, the effect is to revive the first statute, unless a contrary intention is indicated in the third statute. General consequences of repeal. The following are some general effects or consequences of the repeal of an enactment. Later Act abrogates prior one. Repealed Act ceases to exist and does not remain in force with effect from the date of repeal, except in relation to the past and closed transactions. A statute after repeal is completely obliterated as if it had never been enacted. As such, all rights and causes of action under the repealed statute are destroyed. When an act is repealed, all laws passed under it stand repealed unless there is a saving provision. No proceedings can be commenced or continued under an act after its repeal. After the repeal of a statute, the law which was in force at the commencement of the repealed statute revives. A law can be retrospectively amended to validate the transactions made under it, even after its repeal. When an existing statute is repealed by a temporary statute, it is a temporary repeal. After the expiry of such temporary act, the repealed act revives. The statute is completely obliterated and all rights under repealed statute are destroyed. Next, effects embedded under the General Clauses Act 1987. Section 6 of the General Clauses Act provides that where this act or any central act or regulation made after the commencement of this act repeals an enactment hitherto made or hereafter to be made, and unless a different intention appears, the repeal shall not revive anything not in force or existing at the time at which the repeal takes effect, or affect the previous operation of any enactment so repealed, or anything duly done or suffered thereunder, affect any right, privilege, obligation, or liability acquired, accrued, or incurrent under any enactment so repealed, or affect any penalty, forfeiture, or punishment incurred in respect of any offence committed against any enactment so repealed, or affect any investigation, legal proceeding, or remedy at the request of any such right, privilege, obligation, liability, penalty, forfeiture, or punishment as aforesaid. Conclusion. It can be concluded the repeal of statutes means the abolition of the law And once, if any statute is abolished, then it is considered void and possesses no effect. In addition, there is no basic difference between amendment and repeal. Both the term amendment and repeal is used for stating similar expression that it is substitution or omission or addition. Both the union and the state legislature are empowered with such power, however, they are restricted to delegate the power of repealing. The primary object of this act is to bring necessary changes in the existing law for changing the socio-economic and cultural conditions from time to time. The purpose of this act is to remove the outdated or obsolete matter from the body of law. After removal of the obsolete matter, it is the court that decides whether the new provisions meet its goal and has a different intention or not. This act is the editorial revision by abolishing obsolete or unnecessary matter and of the statute and adding new or proper information on the basis of the statute. Fourth question. Wow. IOS. Interpretation of substantive and procedural or adjective laws. Substantive law is the statutory or written law that defines rights and duties, such as crime and punishment in a criminal law, civil rights and responsibilities in civil law. It is codified in legislative statutes or can be enacted through the initiative process. Substantive law is a statutory law that deals with the legal relationship between people or the people and the state. Therefore, substantive law defines the rights and duties of people. Methods of interpreting substantive law. Introduction. Interpreting is the process by which the court seeks to ascertain the meaning of a particular legislation. Interpretation is the art of a process of discovering and expounding the meaning and intention of the authors of the law with respect to its application to a given case, where that intention is rendered doubtful, among other, by reason of the fact that the given case is not explicitly provided for in the law. To interpret substantive law, jurists follow the following methods. 1. Strict interpretation. It is a sound rule of construction that the substantive law should be construed strictly so as to give effect and protection to the substantive rights unless the statute otherwise intends. Strict construction is one which limits the application of the statute by words used. According to Sutherland, strict construction refuses to extend the import of words used in a statute so as to embrace cases or acts which the words do not clearly describe. With reference to the purpose and object of the statute. As long ago, Haydn's case, Lord Coke said that it was resolved that for sure and true interpretation of statutes, 4 things are to be discerned, recognized, and considered. What was the common law before making of the act? What was the mischief or defect for which the common law did not provide? What remedy the Parliament has resolved and appointed to cure the disease of the Commonwealth? The true reason of the remedy and the office of all the judges is always to make such construction as shall suppress the mischief and advance the remedy. Next, rules of harmonious construction. It is settled rule of interpretation that all provisions which read together harmoniously so as to give effect to all the provisions as a consistent whole, rendering no part of the provision as a surplusage. The well-known principle of harmonious construction is that effect shall be given to all provisions, and for that any provision of the statute should be construed with reference to the other provisions to make it workable. A particular provision cannot be picked up and interpreted to defeat another provision made in that behalf under the statute. In Sultana Begum versus Premchand Jain, the essence of the rule of harmonious construction has been explained as under. It is the duty of the courts to avoid a head-on clash between 2 sections of the Act. The provision of one section of a statute cannot be used to defeat the other provisions unless the court, despite its efforts, finds it impossible to effect a reconciliation between them. Courts have also to keep in mind that an interpretation which reduces one of the provisions as a dead letter or a useless lumber is not harmonious construction. To harmonize is not to destroy any statutory provision or to render it odious, serving no practical purpose. Next, the prospective effect of substantive law. The general rule of construction of substantive law is unless an enactment expressly provides for retrospective operation, it has to be construed as prospective. Unless there are words in the statute sufficient to show the intention of the legislature to affect existing rights, it is deemed to be prospective. Methods or canons of interpreting procedural law. Introduction. Salmon defined the law of procedure is the branch of law which governs the process of litigation. It is a law of action, using the term action in a wide sense to include all legal proceedings, civil and criminal. Procedural law is the machinery for enforcing those rights and duties of substantive law. Procedural law comprises the rules by which a court hears and determines what happens in civil or criminal proceedings, as well as the method and means by which the substantive law is made and administered. Procedural law comprises the set of rules that govern the proceedings of the court in criminal lawsuits as well as civil and administrative. The court needs to conform to the standards set up by procedural law, while during the proceedings these rules ensure fair practice, consistency in the due process. The jurist's function is to rise above the particular enactment and factual situation. He must follow some procedural principles to expound the intent of the legislature. To interpret the procedural law, jurists follow the following methods or procedures. A. Rule of liberal construction. It is a sound rule of construction that the procedural enactment should be construed liberally and in such a manner as to render the enforcement of the substantive rights effective. Liberal construction means to give language of a statutory provision freely and consciously. It is commonly generally accepted meaning to the end that the most comprehensive application thereof may be accorded without doing violence to any of its terms. The end of all procedure is to facilitate justice and not to defeat it. In construing a provision which is a procedural one, the norm of liberal construction must be borne in mind. Statutes relating to remedies and procedures must receive a liberal construction, especially so as to secure a more effective, a speedier, a simpler, and a less expensive administration of law. Harmonious construction. Maxim. Injustum est nisi tota lege inspecta. De una aliqua ejus particula proposita judicare vel responder. It is unjust to decide or respond to any particular part of law without examining the whole of the law. Harmonious construction is the interpretation of statutes. It is a recognized rule of interpretation of statute that the expression used therein should ordinarily be understood in a sense in which the best harmonize with the object of the statute and which effectuate the object of the statute and the legislature. In a statute like the Code of Civil Procedure, which has large number of sections with its numerous orders and still more numerous rules thereunder, it is of great importance that, if possible, construction of a particular section is not so made as to be in conflict with the other specific section, rules, or orders. Procedural law. Retrospective effect. The statutes dealing with the mere matters of procedure are presumed to be retrospective in the absence of express provision or necessary implication against retrospectivity. In contrast to statutes dealing with substantive rights, harmonious construction. It is unjust to decide or respond to any particular part of law without examining the whole of the law. Harmonious construction is the interpretation of statutes. It is a recognized rule of interpretation of statute that the expression used therein should ordinarily be understood in a sense in which they best harmonize with the object of the statute and which effectuate the object of the statute and the legislature. In a statute like the CPC, with just a large number of sections with numerous orders and still more numerous rules, it is of great importance that, if possible, a construction of a particular section is not so made as to be in conflict with the other specific section, rule, or order. Procedural law. Retrospective effect. The statutes dealing with the mere matters of procedure are presumed to be retrospective in the absence of express provision or necessary implication against retrospectivity. In contrast to statutes dealing with substantive rights, statutes dealing with the matters of procedure are presumed to be retrospective unless such a construction is textual inadmissible. When an amendment act affects the matters of procedure only, it applies to all actions pending as well as future, because the change in procedure does not alter the substantive rights of the citizen. Ignoring the technical defect. According to Lord Reid, the canons of construction are not so rigid as to prevent a realistic solution. In Muhammad Tahir versus Muhammad Wahab, it has been observed that any technical defect in the procedure should be ignored in the issue of public concern. Violation of any procedural provision cannot automatically make the inquiry or order void. Rules of procedure have to be interpreted in a manner that may substantiate the cause of justice as well as to avoid delay. Next, rules of construction under General Clauses Act 1897. The General Clauses Act 1897 is a consolidating and amending act, as is clear from the long title of the act. The purpose of the act is to avoid superfluity and repetition of language, and to place in a single act provisions as regards to definitions of words and legal principles of interpretation, which would otherwise have to be incorporated in many different acts and regulations. General rules of construction. Coming into operation of enactment, section 5. Where any central act is not expressed to come into operation on a particular day, then it shall come into operation on the day on which it receives the assent of the President. Effect of repeal, Section 6. Where this act or any central act or regulation made after the commencement of this act repeals any enactment hitherto made or hereafter to be made, then unless a different intention appears, the repeal shall not 1. Revive anything not in force or existing at the time at which the repeal takes effect, affect the previous operation of any enactment so repealed, or anything duly done or suffered thereunder, or affect any right, privilege, obligation, or liability acquired, accrued, or incurrent upon enactment so repealed, or affect any penalty, forfeiture, punishment incurred in respect of any offence committed against any enactment so repealed, or affect any investigation, legal proceeding, or remedy in respect of any such right, privilege, obligation, liability, penalty, forfeiture, or punishment as aforesaid. And any such investigation, legal proceeding, remedy may be instituted, continued, or enforced. And any such penalty, forfeiture, or punishment may be imposed as if the repealing act or regulation has not been passed. Repeal of the act makes textual amendment in act or regulation, Section 6A. Where any central act or regulation made after the commencement of this act repeals any enactment by which the text of the central act or regulation was amended by the express omission, insertion, or substitution of any manner, then, unless a different intention appears, the repeal shall not affect the continuance of any such amendment made by the enactment so repealed and in operation at the time of such repeal. Revival of repealed enactment, Section 7. In any central act or regulation made after the commencement of this act, it shall be necessary for the purpose of reviving either wholly or partially any enactment wholly or partially repealed expressly to state that purpose. Construction of references to repealed enactment, Section 8. Commencement of termination of time, Section 9. In any central act or regulation made after commencement of this act, it shall be sufficient for the purpose of excluding the first in a series of days or another period of time to use the word from, and for the purpose of including the last in a series of days or any other period of time to use the word to. Computation of time, Section 10. Any act or proceeding is directed or allowed to be done or taken to any court or office on a certain day or within a prescribed period, then if the court or office is closed on that day or the last day of the prescribed period, the act or proceeding shall be considered as done if it is done on the next working day. Measurement of distances, Section 11. The distance shall, unless a different intention appears, be measured in a straight line on a horizontal plane. Duty to be taken pro rata in enactment, Section 12. Whereby any enactment now in force or hereafter to be enforced, any duty of customs, excise, and the nature thereof is leviable on any given quantity by weight, measure, or value of any goods or merchandise, then a like duty is leviable according to the same rate on any greater or lesser quantity. Gender and number, Section 13. Words importing the masculine gender shall be taken to include female, and words in singular shall include the plural and vice versa. Next, general principles of interpretation. Rules of statutory interpretation. Following are considered as general principles of interpretation. 1. The intention of legislature predominates. A statute is an edict, an official order of the legislature. The object of the court in interpreting a statute is to find out the intention of the legislature as expressed in the statute. The intention of the legislature has two aspects: meaning of the words used and the purpose and object, and the reason and spirit pervading the true statute. According to Blackstone, the most fair and rational method for interpreting a statute is by exploring the intention of the legislature through the most natural and probable signs, which are either the words, the context, the subject matter, the effect, the consequence, or spirit or reason of the law. It may be concluded that the intention of legislature is the most important factor for administering justice in accordance with the law. If courts fail to derive the true intention, it could not only lead to a miscarriage of justice but may also defeat the very purpose of the statute. The intention of legislature must primarily be gathered from the language itself. 2. A construction to avoid absurdity is justifiable. The rule of harmonious construction. While interpreting the statute, the courts are permitted to avoid absurdity and to apply harmonious construction. In Sultan Begum vs. Premchand Jain, the Supreme Court observed that the rule of interpretation requires that while interpreting two inconsistent or obviously repugnant provisions of an act, courts should make an effort to so interpret the provisions as to harmonize them so that the purpose of the act may be given effect to, and both the provisions may be allowed to operate without rendering either of them odious, serving no practical purpose. Third, same word to have the same meaning unless otherwise intended. When a legislature uses the same word in different parts of the same section or statute, there is a presumption that the word is used in the same sense throughout. This rule says that where the draftsman uses the same word or a phrase in a similar context, he must be presumed to the intent it in each place to bear the same meaning. Vanchu in Bhogilal Chunilal Pandya versus State of Bombay observed that the words are generally used in the same sense throughout in a statute unless there is something repugnant in the context. For statute should be read as a whole in its context, that ex viceribus actus. The meaning of the maxim ex viceribus actus is that every part of the statute must be construed within the four corners of the act. In other words, no provision should be interpreted in isolation. Wherever the language of a provision is ambiguous and open to alternative constructions due to uncertainty of the meaning of the words and used therein, the provision has to be read as a whole in its context. It is not permissible to omit any part of it, and the construction of a section should be made of all parts together. It is the rule now firmly established that the intention of the legislature must be found by reading the statute as a whole. If it is better to validate a thing than to invalidate it, utres magis valiat quam pariat. It is better to validate a thing than to invalidate it. The maxim utres magis valiat quam pariat lays down that it is better for a thing to have an effect than to be made void. A statute should be interpreted so as to make it effective and operative. In Tinsukia Electric Supply Company versus Assam, the Supreme Court observed that a statute or enacting provision therein must be so construed as to make it effective and operative. However, if a statute is absolutely vague and its language is wholly intractable and absolutely meaningless, the statute can be declared void for vagueness. 6. Express mention of one thing implies the exclusion of another. Expressio unius est exclusio ulterius. The maximum expressio unius est exclusio ulterius indicates that if one or more things of a particular class are expressly mentioned in an enactment, that means that other things belonging to the same particular class are excluded from the domain of the enactment. Hukka. Again, where two expressions have been used in a statute, one of which generally includes the other, the more general expression includes the less general. In India, the fundamental rights under Article 15, 16, 19 are available to the citizens of India and not to other persons and non-citizens, and thus are expressly excluded as they are not citizens. However, Indian citizens may claim these freedoms through their legal persons because the relief ultimately goes to the citizen and not to the legal person. 7. Expression precludes implication. Expressum facit cessare tacitum. The maxim expressum facit cessare tacitum is analogous to the principle expressio unius personae vel rei est exclusion ulterius, and it connotes that when there is an express mention of certain things, then anything not mentioned is excluded. In other words, the maxim lays down that expressed words put an end to implication. 8. Contemporaneous expression is the best and strongest in law. Contemporanea exposito est optima et fortissimo in lege. The maxim contemporanea exposito est fortissima in lege means that contemporaneous expression is the best and strongest in law. The language of a statute must be understood in the sense in which it is understood when it is passed. Those who live at on near the time when it was passed may reasonably be supposed to be better acquainted than their descendants with the circumstances to which it has related, as well as with the sense then attached to the legislative expression. The principle that the language used by the lawmakers must be interpreted in its natural and ordinary sense suggests that the sense must be the same with the words used ordinarily had at the time the statute was enacted. Associated words, nocitor a socis. The word nocitor means to know and socis means association. Therefore, nocitor a socis means to know from the association. Nocitor a soci means the meaning of a doubtful word may be ascertained by reference to the meaning of the words associated with it. Rule of construction, nocitor a socis, as explained by Lord Macmillan. The meaning of a word is to be judged by the company it keeps. As stated by Privy Council in Angus Robertson versus George Day, it is a legitimate rule of construction to construe words in an Act of Parliament with reference to words found in immediate connection with them. 10. Ejusdem generis of the same kind. The term ejusdem generis means of the same kind. The rule of ejusdem generis provides that where words of specific meaning are followed by general words, the general words will be construed as being limited to persons or things of the same general kind or class as those enumerated by specific words. The rule of ejusdem generis is the rule of construction, which lays down that when particular words are followed by general words, the meaning of the general words is to be understood with reference to the particular words. The general words are limited to the same kind as the particular words. This rule restricts the meaning of general words to things or the matter of the same kind as the preceding specific words. The rule ejusdem generis is also known as Lord Tenterham's rule. For example, in the expression bread, butter, jam, a series of words are used which are edible. Therefore, they constitute one genus, and the word etc. is a general word. It may carry any meaning but restricted to edibles only. Thus, etc. as may mean biscuit, cake, since they are edibles, but it cannot be an apple. Golden logical rule of interpretation. How is it different from the grammatical rule? What is golden rule? The golden rule is a modification of the literal rule. Golden rule allows a departure from the strict literal rule by recourse to consequences of applying a natural and ordinary meaning. The golden rule is used to remove absurdity. It comes into existence where some doubt existed as to the meaning of a word. Origin of Golden Rule. In the year 1857, for the first time, Lord Wensleydale propounded the Golden Rule of Interpretation in Gray versus Pearson. Thereafter, this rule has become famous by the name Wensleydale's Golden Rule. Meaning of a Golden Rule. The Golden Rule, or a British rule, departs from its strictly literal rules. It is elaboration or extension of the literal rule. The Golden Rule of Interpretation allows judges to depart from the word normal meaning in order to avoid an absurd result. According to Maxwell, the golden rule is that words of institute must prima facie be given their ordinary meaning. According to the golden rule in the construction of a statute, the court must adhere to the ordinary meaning and grammatical construction of the words used. It's a modification of the principle of literal or a grammatical interpretation. The golden rule can be used in two ways. The golden rule can be used in a narrow sense and a wider sense. Importance of the golden rule of interpretation. It departs from the strictly literal rules. The court adopts the golden rule of interpretation in order to arrive at a perfect interpretation, which will bring out the true meaning of the language in the process of giving effect to the real intention of legislature. The golden rule in a nutshell. The golden rule of interpretation contains the following points. Modification of literal rule. Different from the literal rule. Application of literal rule may lead to absurd interpretation of a statute. Golden rule tries to avoid the absurd and abnormal result. Application of golden rule. Application of golden rule depends upon the consequences. Where the situation demands the application of a golden rule, it is important to consider the effect or consequence which would result to come out of it. For the one point out the real meaning of the word. Advantages and disadvantages of the golden rule. Here are some advantages and disadvantages of the golden rule, which are as follows. Advantages of golden rule. With the help of golden rule, errors in drafting can be corrected immediately. Decisions are made more in line with Parliament intentions. It helps to give a rational result. It helps in closing any loophole. It brings common sense to the law. It allows the court to make sensible decisions. It prevents the Parliament from having to pass amending legislation. It respects the authority of the Parliament because it only allows wording to be altered in a very limited situation where the outcome would be absurd or repugnant. Disadvantages of the golden rule. Infringe the separation of powers. Judges have no power to intervene for the pure justice when there is no absurdity. Judges cannot add or modify a statute. It only allows judges to change the wording of the statute in a very limited circumstance. Michael Zander describes it as a feeble parachute because it is not of much use. It could not be used in cases like Berryman case because although the situation could be considered unfair, it was not absurd or repugnant. It is unpredictable and lacks guidelines. Relevant case laws. Lee versus Knapp, 1967. Accident case. In this case, the interpretation of the word stop was involved. Under section 77(1) of the Road Traffic Act, a driver causing an accident shall stop after the accident. In this case, driver stopped for a moment after causing an accident and then moved away. Applying the golden rule, the court held that the requirement of the section had not been followed by the driver as he had not stopped for a reasonable time of period, requiring interested persons to make necessary inquiries for him about the accident. In Tarlochan Dev Sharma versus State of Punjab, question of interpretation of the words abuse of his powers in the expression abuse of his powers or habitual failure to perform his duties. In section 22 of Punjab Municipal Act was involved. The Supreme Court observed that to find the meaning of the word not defined in enactment, the courts apply the subject of enactment where the word occurs and have regard to the object which the legislature has in view. In selecting one out of the various meanings of a word, regard must always be had to the context. Abuse of power in the context implies a willful abuse or an intentional wrong. An honest though erroneous exercise of power or indecision is not an abuse of power. The distinction between grammatical and golden interpretations. Grammatical. It is also called literal interpretation. Golden. It is also called functional interpretation. Grammatical. It depends upon the letter enacted law, that is literal leges. Golden. It depends on the spirit of the enacted law, that is legislative intent. Grammatical. It interprets only the verbal expression of the statute. It does not go beyond literal leges. Golden. It looks beyond the literal leges. It seeks elsewhere for some other or more satisfactory evidence to find out the truth. Literal. In grammatical interpretation, the words construed according to the popular or dictionary meaning of the term. It gives plain, natural, ordinary meaning. In golden, when grammatical interpretation fails, logical interpretation comes into help. It is to find out the sententia legis, legislative intent, from other sources, that is external and internal aids of the statute. Grammatical. It is used frequently. Golden. It is used rarely. Grammatical. It is the most traditional one. Golden. Logical interpretation developed after the grammatical interpretation came into existence. Grammatical. It is a very old rule. Golden. Lord Wensleydale propounded this rule in the case of Gray versus Pearson. Next, mischief rule and its importance. Hayden's rule. The mischief rule is the third rule of statutory construction, traditionally applied by the English courts. The other two are the plain meaning rule, or the primary rule, or literal rule, or grammatical rule, and the golden rule. The mischief rule is narrower application than the golden rule or plain meaning rule, in that it can only be used to interpret a statute, and strictly speaking only when the statute was passed to remedy a defect in common law. The application of the mischief rule gives the judge more discretion than the literal and golden rule, as it allows him to effectively decide on Parliament's intent. Meaning of mischief rule. Mischief rule of construction is that court must adopt that construction which will suppress the mischief and advance the remedy by looking to what the law was before the statute was passed in order to discover what gap or mischief the statute was intended to cover. Mischief rule is the rule of interpretation in which the interpretation is done in such a way so as to suppress the mischief intended to be remedied by statute. The mischief rule says that judges must go deep to see the intention of the legislature and object of the statute to find out what is the mischief sought to be remedied by the legislature. For this purpose, the court may take the assistance of counsel to refer all materials connected with the statute, such as press agitation, comment of legal experts, journals, debates on the floor of Parliament, law commission reports. Mischief rule is applicable only when the words in question are ambiguous and are reasonably capable of more than one meaning. The court is entitled to ascertain the intention of the legislature, to remove the ambiguity by construing the provision of the statute as a whole, keeping in view what was the mischief when the statute was enacted, and to remove which the legislature enacted the statute. It would be the duty of the courts to adopt the construction which would advance the object of underlying act. The main aim of the mischief rule is to determine the mischief and defect that the statute in question had set out to remedy, and what ruling would effectively implement this remedy. Hayden's rule. The mischief rule was first laid out in Hayden's case. In this case, the college had certain properties in its own name. The management had given certain land to W and his son for their lives, and after them to S and G. In England during 16th century, there existed a system called doubling of estates, and the giving of property in the above way was valid. During those days, misappropriation of the properties of ecclesiastical and religious institutions was going on through the system of doubling of estates. To prevent the doubling of estate, the England Parliament enacted the Statute 31 Henry VIII. Under this act, the properties of the college were taken away by Crown, and also the previous leases and instruments were cancelled. Hayden challenged in the court. Court took the guidance of the mischief rule of interpretation and upheld the Statute 31 and also Act of the Crown. The object of the Parliament was to protect the properties of ecclesiastical relating to Christian church and clergy and religious institutions. Status 31 provided the remedy to protect with that object. In Hayden's case, the court ruled that there were 4 points to be taken into consideration when interpreting a statute. In this case, Lord Coke observed the following: that for sure and true interpretation of all statutes in general by the penal or beneficial, restrictive or enlarging the common law, 4 things are to be considered. What was the common law before the act? What was the mischief and defect for which common law did not provide? what remedy the Parliament had resolved and appointed to cure the disease of the Commonwealth, and the true reason of the remedy, and then office of all the judges is always to make such construction as shall suppress the mischief and advance the remedy, and to suppress subtle inventions and evasions for the continuance of the mischief, and pro privato commodo, and to add force and life to the cure and remedy, according to the cure and remedy, according to the true intention of the makers of the act pro bono publico. Mischief rule was applied in Smith versus Hughes. It deals with State Offences Act 1959, where it states that the common prostitute to loiter or solicit in a street for the purpose of prostitution, where a street indicated that it was a place and not a person. The overall case was to deal with the cleaning of the street for people to walk along the street without being molested and solicited by prostitute. The prostitute would be penalized and arrested and would be found guilty of the offence if they were soliciting in the streets. In this case, the question was whether a woman who had tapped on a balcony and hissed at men passing by was guilty of an offence under the Act. Parker LCJ found her guilty. He says, I approach the matter by considering what the mischief is aimed at by this Act. Everybody knows that this was an act intended to clean up the streets, to enable people to walk along the streets without being molested or solicited by common prostitutes. Viewed in this way, it can matter little whether the prostitute is soliciting while in the street or standing in a doorway or up in a balcony. Purposive construction. The mischief head rule is also known as the rule of purposive construction, since it emphasizes advancing the purpose and object of the statute. Relevant cases in India. In Conversing versus Delhi administration, the officers of the respondents, while rounding up stray cattle, were beaten up by the appellants, the owners of the cattle. When prosecuted for the offence under Section 332 Indian Penal Code, the appellants pleaded right of private defence of property. They also contended that the cattle were not abandoned within the meaning of 418 Delhi Municipal Corporation Act 1957, in that the abandoned means completely leaving a thing as a final rejection of one's responsibility, so that it becomes ownerless, as have been described in the dictionaries. The Supreme Court, while rejecting this argument, held that it is not necessary that the dictionary meaning of the word is to be always adhered to, even if the context of enactment does not so warrant. In the present instance, to know the mind of the legislature, it is expedient to see what mischief was intended to be suppressed and what remedies advanced. So interpreted, the word abandoned must mean let loose or left unattended. In Muhammad Nizamuddin versus Mrs. Chemplast Sanmar Limited, the words in or through the port areas are used in Rule 5 of the Environment Protection Rules 1986, made under Section 25 Environment Protection Act 1986. There is a prohibition on the manufacture, handling, or storage of hazardous substances in a coastal regulation zone under Coastal Regulation Zone Notification of 1991. An exception to this was, however, carved out, permitting transfer of hazardous substances from ships to ports, terminals and refineries and vice versa in the port area. Supreme Court held that the words in the port area have to be given purposive construction, and so construed they must be read as in and through the port areas. The words as used in Rule 5 of the Environment Protection Rules 1986. Rules of strict construction are of penal statutes, its strength and weaknesses. What is a penal statute? A penal statute is one which imposes a pecuniary penalty or other punishment for an offence. A penal statute is one which provides a penalty for some offence of a public nature. Penal statute provides for penalty for disobedience of the law by the offender by making him liable for punishment, fine, forfeiture, or even death. If the statute enforces obedience to the command of the law by punishing the offender and not merely redressing an individual who may have suffered, the statute is penal. The rule of strict construction of penal statute. The rule is stated by Mahajan CJ in Tolaram versus State of Bombay is that if two possible and reasonable constructions can be put upon a penal provision, the court must lean towards that construction which exempts the subject from penalty, rather than the one which imposes a penalty. It is not competent to the court to state the meaning of expression used by the legislature in order to carry out the intention of the legislature. In State of Jharkhand versus Ambe Cement, Supreme Court held that it is settled rule of interpretation that where a statute is penal in character, it must be strictly construed and followed. The basic rule of strict construction of the penal statute is that a person cannot be penalized without a clear letter of the law. Presumption or assumption have no role in interpretation of penal statutes. They are to be construed strictly in accordance with the provisions of law. Nothing can be implied. In such cases, the courts are not so much concerned with what might possibly have been intended. Instead, they are concerned with what has actually been said. Guiding principles of strict construction of penal statutes. From the rules enunciated by different courts in different cases, the following guiding principles can be formulated. In criminal cases, strict construction is the general rule of construction. If the penal section covers only some cases of persons, their essence cannot be extended to cover other persons. Section 82 of IPC deals with the act done by a child below 7 years of age. Section 83 deals with the act of children who are above 7 but below 12 years of age. The two sections make no provision for an infant who is of exact 7 years. It is submitted that such an infant should be dealt with under Section 82 of the Code because penal statutes are to be interpreted strictly. In order to warrant a conviction for an offence, a case must fall within the ambit of the definition of the offence charged, and the rule is that the benefit of all reasonable doubt must always go to the accused. If there is no ambiguity and the act or omission by the accused falls clearly within the mischief of the statute is to be interpreted like any other law. There is full effect given to the statute. Penal statutes generally have a prospective operation. No penal statute should be given a retrospective operation, as per Article 20, Clause 1 of the Indian Constitution. Where a certain procedural requirement have been laid down by a statute to be completed, in a statute dealing with punishment, the court is duty-bound to see that all these requirements have been complied with before sentencing the accused. Relevant cases. In Rahul Hari Prasad Rao versus State, a servant of the appellant delivered petrol to 3 cars without taking coupons from them. This was in violation of the clauses 5 and 22 of the Motor Spirit Rationing Order 1941, made under Rule 81(2) of the Defence of India Rules. Since no coupons were taken from them, necessary endorsements were also not made at the back of the coupons, as required by Clause 27A of the order. On being prosecuted for these illegal omissions, the appellant proved that on the day of the occurrence, he was out of the station. Consequently, in the absence of mens rea, he could not be punished. The Supreme Court held that mens rea was an essential element to be proved under clauses 5 and 22. Since the appellant was out of station on the day, he could not be held responsible for the mistake of his servant, who should have taken coupons from the customers. But the appellant was guilty under clause 27A because this provision casts a strict liability on the petrol dealer. Object of this enactment was that the petrol dealer should set up complete machinery to ensure that necessary endorsements are made on the coupons against which petrol are supplied. Even if the endorsements could not be made because of the fault of the servant, appellant could not escape liability because he has failed to ensure compliance of the law. In case Kedarnath versus State of West Bengal, offence under the Act was punishable with imprisonment or a fine. Both was committed by appellant in 1947. Act was amended and the punishment in the form of fine was enhanced to the tune of amount equivalent to the amount procured by the offender through his offence. Supreme Court held that this enhanced punishment could not be meted out to the offender in view of the clear provisions of Article 20, Clause 1 of the Constitution, which says that no penal statute should be given a retrospective operation. Next, principles of strict construction of penal statute as laid down by Maxwell. According to Maxwell, the strict construction of penal statute seems to manifest itself in 4 ways. The first way, express language. The first requirement is that the offence in the statute must be manifestly defined with accurate terms and without any ambiguous meanings. An act or omission may be treated as an offence and it depends upon the definition given by the concerned penal statute. Second way, explanation of offence. Legislature must explain the elements of an offence. It must mention clearly the essential condition in which the act of a person can be treated as an offence. Third way, punishment. Imposing punishment is the essential ingredient of penal statute. For the graver offences, punishment should be severe, such as imprisonment, rigorous or simple. For lighter offences, penalty by way of fines. In certain offences, either imprisonment or penalty or both. Fourth way, jurisdiction and procedure. The Criminal Act must be inquired and tried by the competent court in the prescribed procedure. Next, beneficial liberal construction with illustrations. Meaning of the beneficial statute, welfare, socio-economic and remedial statute. A statute will purport to confer a benefit on the individuals or a class of persons by relieving them of the onerous obligations under contracts entered into by them, or which tend to protect the persons against oppressive act from individuals with whom they stand in certain relations is called the beneficial legislation or statute. Beneficial statutes may be in the form of remedial statutes, welfare statutes, and socio-economic statutes. A remedial statute is one which remedies defect in the pre-existing law, statutory or otherwise, for the benefit of society and to suit to the changed conditions of society. A welfare statute is one which aims to look after the well-being of the people by keeping good health and enjoying all good things in life. A socio-economic statute is one which is made with the object of securing social and economic welfare of the deprived class of society and the economic development of the nation. Directive Principles of State Policy, Part 4. The Constitution or beneficial legislation to the citizens. As per directives, Indian government enacted several statutes for the benefit of people. Some of them are Employee Provident Fund Act, Employee Pension Scheme, Payment of Gratuity Act, Payment of Bonus Act, Employees Family Pension Scheme, Right of Children to the Free Remuneration Act. Rule of beneficial construction of statute. Beneficial construction rule depends upon the legal maxim Salus populi est suprema lex. It is welfare of people is the supreme from law. The welfare or beneficial statutes contain certain beneficial provisions and remedies. The legislature intend to render benefit to weaker sections. The courts, while interpreting the beneficial or welfare statute and other statutes, should follow the following principles or guidelines. Courts should take a generous view. The principle established in the construction of a statute is that where there is no room for taking a narrow view, but that the court is entitled to be generous toward the person on whom the benefit has been conferred. Third, the court shall adopt that construction which advances, fulfills, furthers the object of the act rather than the one which would defeat the same and render the protection illusory. A beneficial piece of legislation has to be construed in its correct perspective so as to fructify the legislative intent underlying its enactment. When two views are possible on applicability to a given set of employees, that view which furthers the legislative intent should be preferred to the one which frustrates it. Construction should serve the purpose of enactment and should not defeat it. Construction should be such that no part of the enactment is rendered odious or surplusage. When the beneficial legislation is construed, a wider interpretation must be given for the advantage of a section of people, the target group of enactment. While construing the beneficial legislation, the courts must look at them as they are constitutionally valid or not. Courts should also adopt a construction which advances the policy of the legislation to extend the benefit rather than the one which curtails the benefit. Literal construction is not the invariable rule. The court should construe meaningfully in appropriate cases. If literal meaning produces an anomalous or deviating from what is standard, normal, or expected, absurd and unfair result which may be violative of the Constitution, the court should avoid it and adopt a construction which would advance the object and purpose of the provisions of the statute. The court should make a purposeful interpretation so as to effectuate the intention of the legislature and not a purposeless one in order to defeat the intention of the legislator wholly and partly. According to the beneficent construction, where an act does not expressly confer a right to the workman but does not indicate any negative intention either, that act must be construed in the interest of workmen. Benignant beneficiary provision must receive a benignant construction, and even if two interpretations are possible, which furthers the beneficial object should be preferred. The language of the beneficial statute must be construed so as to suppress the mischief and advance the remedy. Illustration. In B. Shah versus Presiding Officer, question before the court was the interpretation of Section 5 of Maternity Benefit Act, under which an expectant mother employee could take a maximum of 12 weeks of maternity leave, pre-birth, post-birth, and full salary. The facts in that case were that a woman worker who went on maternity leave was paid 72 days wages calculated on the basis of 6-day week for 12 weeks, omitting 12 Sundays. She contended that she should be paid wages for 84 days as week consisting of 7 days. The Supreme Court ordered to pay wages for 84 days and stated that the statute is a beneficial piece of legislation intended for the purpose of achieving social justice for women workers. Article 42 of the Constitution has recognized it as a directive principle of state policy. The policy behind Section 5 of the Maternity Benefit Act is that the mother worker should not only be able to meet her both ends during the leave period but also be able to revitalize some of her diluted earnings with a view to maintaining her efficiency as a worker, as also to be able to nurse her newborn child. Being beneficial legislation with such a noble object in view, enactment has to be interpreted beneficially. In Spring Meadows Hospital versus Ahluwalia, Supreme Court held that if the parents have hired services of a hospital for the benefit of their child, they and child can maintain independent action against the hospital for deficiency of service. Andhra University versus Regional Provident Fund Commissioner. The Supreme Court held that the Employees Provident Fund Miscellaneous Provisions Act is a beneficent piece of social order. Welfare legislation should be aimed at promoting, securing well-being of the employees, and the court will not adopt a narrow interpretation of which will have the effect of defeating the very oldest and the purposes of the Act. Once it is found that there is an establishment in the incident case, the Department of Publication and Press University, which in a factory engaged in industry specified in Schedule 1 and employing 20 or more persons, the provisions of the Act will get retracted to the case, and it makes no difference to the legal position of the establishment done by a legal organization, which may be carried on either additional activities outside. Internal aids of interpretation. of statute. Preamble important. Interpretation means the process of ascertaining the true meaning of the words used in a statute. Object of interpretation of statutes is to determine the intention of the legislature conveyed expressly or impliedly in the language used, as stated by Solomon. By interpretation or construction is meant the process by which the court seek to ascertain the meaning of a legislature through the medium of authoritative forms in which to express. Judges take the help of both rules and rights in interpretation of state. As stated by the Supreme Court in KP Varghese versus Income Tax Officer, interpretation of a statute being an exercise in ascertainment of meaning. Everything which is logically relevant should be admissible. A rule is a uniform established course of things. There are three rules of interpretation of statutes: literal, golden, and mischief. Aid, on the other hand, is a device that helps or assists for the purpose of construction or interpolation. The courts have to take recourse to various internal and external aids. Internal aids. Internal aids mean those aids which are available to the statute itself, though they may not be part of the enactment. Some literal aids are: title of the statute, long title. Every statute has headed by a long title and it gives the description of the object of an act. Long title of the Code of Civil Procedure. An act to consolidate and amend the laws relating to procedure of Court of Civil Procedure. In recent times, the long title has been used by courts to interpret certain provisions of statute. However, it is useful only in the extent of emerging ambiguity and confusion, and is not a conclusive interpret provisions of the statute. Cases. In the Kerala Education Bill, Supreme Court held that the policy and purpose may be directed from the long title and preamble. Manohar Lal versus Son of Punjab. The long title of the Act is relied upon as a guide to decide the scope of the Act. Although the title is a part of the Act, it is in itself not an enacting provision, and though it is useful in case of ambiguity of enacting provisions, it is ineffective to control their clear meaning. Short title. The short title of the Act is for the purpose of reference to its identification. It ends with the year of the passing of the Act number Section 1 CRPC. Act may be called as the Code of Civil Procedure. Preamble. The main objective and purpose of the Act are found in Preamble of Statute. It is a preparatory statement and contains the recitals showing the reason for Customs Act. Example: the Preamble of the Indian Penal Code 1860 is, whereas it is expedient to provide a general penal code for India, it is enacted as follows. The Preamble is an intrinsic aid in the interpretation of the ambiguous Act. Parliamentary practice to include the Preamble as a part of the Act was discontinued since long and generally long title has replaced it. The Preamble of a statute is a perfunctory statement, as being following the entire title and proceeding of the enacting clauses declaring the policy and purpose, reason and motive for, and the objects sought to be accomplished by the Act. Reference to statement of objects and reasons, permissible to understanding the background, that antecedent state of surrounding circumstances, in relation to the statute and the evil which the statute was sought to remedy. The Preamble, being a part of the statute, can be read along with other portions of the Act to find out the meaning of words in enacting provisions, as also to decide whether they are clear or ambiguous. The Preamble is the key to open the minds of the makers of the Act and the mischief which they intended to redress. Cases. In Powell versus Kempton Park, it is settled that the Preamble cannot be made use to control the enactment themselves when they are expressed in clear and unambiguous terms. The Preamble affords a clue to the scope of the statute, where the words construed in them without the aid of Preamble are capable of more than one meaning. We must not create or imagine an ambiguity in order to bring to the aid of the Preamble. In Barkasur Coal Company, in Borakot Coal Company versus Union of India, Madholkar Ji observed it is a cardinal principle of construction that where language of an act is clear, the Preamble must be disregarded, though where the object or meaning of the enactment is not clear, the Preamble may be resorted to explain. We cannot start with the Preamble for the construing the provisions of an act, though we could be justified in reasoning to it, if any, will be required to do so. A.K. Gopalan versus State of Madras, the Supreme Court has held that it is a well-established rule of interpretation that only when the act is unambiguous, a preamble can be made use of to throw light on the express provisions of the act. Where the enactment itself is expressed in the above and unambiguous terms, the preamble cannot be made use of to control it, and ambiguity cannot be created in the mind just to draw a clarification from the preamble, as that would mean frustration and main act. In Kashi Prasad versus State, held that even though the preamble cannot be used to defeat the enacting process of statute, it can be treated as a key for the interpretation of the statute. Interpretation of definition clause. The legislature has power to define the words, expression, terms that may be used in the enactment even artificially. Almost every act contains an interpretation or a definition clause in which those words that may be repeatedly used in the body and different sections of the act are defined. Section 2 of the Code of Civil Procedure 1900 they define decree, judgment, order, public officer, legal representative, because these terms are repeatedly used by the code in its various sections, rules and orders. Object of a definition is to avoid the necessity of frequent repetitions in describing the subject matter to which the word or expression defined is intended to apply. The definition contained in the definition clause of a particular statute, not from any other statute, should be used for the purpose of that act. Headings and title of a chapter. Maxwell stated the headings prefixed to sections or a set of sections in some modern statutes are regarded as a preamble to those sections. They cannot control the plain words of the statute, but they may explain ambiguous words. Cases. In Krishnaya versus State of AP, it was held that the headings prefixed to sections cannot control the plain words of the provisions. Only in case of ambiguity or a doubt, subheading may be referred to as an aid to continuing provision. In Durga Thatera versus Narayan Thatera, court held that the headings are like a preamble which helps to the key to the mind of the legislature but do not control the substantive section of the enactment. Next, marginal or side notes. Marginal or side notes may be found to give a concise indication of the content of the section and to enable the reader at a glance to know through them the drift of the section. As it is a settled rule of interpretation that a marginal note being merely catchwords to a section should not be looked into while interpreting the language of the said section, as that is no part of the section. The general assumption is that the marginal notes are prepared by a person drafting the bill and are in the nature of the gist of the sections are not put by or assented by the legislature. Cases Wilkes versus Goldwyn Banks held that side notes are not part of the act and hence marginal notes cannot be referred to for judgment or challenge of judgment. Illustration. An illustration is to a section has the purpose to illustrate the principle enshrined in the sanitary provision, and it does not exhaust the full content of the section which it illustrates, but equally it is neither cure, curtail nor expand. The illustrations are examples provided by the legislature for both better understanding of the statute. Cases. In Mahesh Chandra Sharma versus Rajkumari Sharma, it was held that the illustration are parts of the section and help to reduce the principles and exponential Section 136 of the Indian Penal Code, harboring deserter, whoever accept as hereinafter accepted, knowing or having reason to believe an officer, soldier, sailor, airman in the Army, Navy, Air Force of the Government of India has deserted, harbors such officer, soldier, sailor, airman shall be punished with imprisonment of either description for a term which may extend to 2 years or fine or both. Exception: this provision does not extend to the case in which the harbor is given by the wife to her husband. Proviso: the name of the clause inserted in the Act of Legislature, a deed, written agreement, or other instrument which generally contains a condition that a certain thing shall or shall not be done, nor that an agreement contained in another clause shall take effect. It always, unlike, implies a condition, unless subsequent words change it to a covenant. But when a proviso contains the mutual words of the parties to a deed, it amounts to a covenant. A proviso differs from an exception. An exceptional exemption exempts absolutely from the operation of the engagement or an enactment. A proviso defeats their operation conditionally. An exception takes up of an engagement or enactment something which would otherwise be part of the subject matter of it. A proviso avoids them by way of deficiency or excuse. A proviso has to provide examples of a specific case which would otherwise fall within the general language of the main enactment. It excludes, overall accepts, and restricts the application of a section in effect and confined to that cases. In CAT versus Ajax Protocol, it was held that whether a proviso is construed as restricting the main provisions of a substantive clause, it cannot be divorced from the provisions to which stands as a proviso. It must be construed harmoniously with the main enactment. Explanations. An explanation is added to the section to elaborate upon and explain the meaning of the words appearing in the scene. The purpose is not to limit the scope of the main section, but to explain, clarify, subtract, or include something by elaboration. Thus, the object of explanation is to provide additional support to the dominant object of the main provisions in order to make meaningful and purposeful discourse. Schedules. The schedule forms an important part of the stage. It should be read along with the schedules are at the end of contain minute details which add information to the provisions of express enactment. The expression is the schedule, however, cannot override the provisions of the general enactment. Punctuation. Punctuation is one of the minor elements of statute. Should be governed by importance only when there is a proper punctuation and used and when there is a doubt about its meaning. Saving clause. A saving clause is generally emphasized to restrict the repealing acts to continue repealing acts in force as to the existing powers, including right, penalty incurred pending process. A saving clause, the nature of an accused was accepted to certain rights, obligations, and penalties may be found in any part of the statute. External aids to interpretation of statutes. Important. Legislative debates. Reference to statutes in pari materia. Materials which are not included in the statute and of which aids are sought in interpreting the statute is known as externals to interpretation of the statute. They are called as surrounding circumstances. These are also called external sources of the statute or extraneous sources of interpretation. External or extrinsic aids may be employed. The construction of statutes if the words and language employed are not free from ambiguity and which cannot be cleared even by resort to intrinsic aids. Extrinsic aids in the construction of statutes are permitted to explain the state of the law at the time it was passed, but not to interpret the act. Further, resources to extrinsic aid in interpreting a statutory provision would be justified only within well-recognized limits, and primarily the effect of the statutory provisions must be judged on a fair and reasonable construction of the words used by the statute itself. In Babwaram v. State of UP, Supreme Court explained the importance of external aid thus. Now we consider the external aid to get at the crux of the question. External aid to interpretation is the secondary source. Following are known external aids to interpretation. 1. Statement of objects and reason for legislation. It is usual with the minister or promoter of a bill in the legislature to attach a statement of objects and reasons when he introduces it in the legislature. It is not part of the bill. It explains the objects and reasons which necessitates the passing of the statute in the legislature. It is only the expression of the mover. The objects and reasons seek to propound the objective which it stands for, so that the members of the House may be convinced of the necessity of introducing the bill. The statement of objects and reasons might be admissible not for construing the act but for ascertaining the conditions which prevailed when the legislation was enacted. Legislative debates, proceedings in the legislature. The minister, while introducing the bill, gives a statement in the legislature. Later, section-wise discussion takes place. Legislature gives their opinion through their statements. Some members propose amendments. A detailed debate takes place in the legislature, and the bill will be passed by a majority vote and becomes a statute. P. V. Narasimha Rao versus State It has been observed that it would be seen that as per the decisions of the Supreme Court, the statement of the minister who had moved the bill in Parliament can be looked at so to ascertain the mischief sought to be remedied by the legislation and the object and the purpose for which the legislation is enacted. The statement of the minister is not taken into account for the purpose of interpreting the provisions of enactment. Historical setting. Events leading up to introduction of the bill. The historical settings means course of events which give rise to enactment. It is also called historical facts, historical background, parliamentary history, history of legislation and surrounding circumstances. The state of affairs existing at the time when a law was enacted are called historical facts. The court is entitled to look into such historical facts as may be necessary to understand the subject matter of the statute or consider the surrounding circumstances or the course of events or events at the time. It may help it to consider whether the statute. Huh? Ah, అదే The rule laid down in Hayden's case that to a certain extent the surrounding circumstances which led to the passing of the Act can be considered for the purpose of construing a statute are now well recognized. In Kashmir Singh versus Union of India, Supreme Court has observed that the courts, while construing an ongoing statute, must take into consideration the changes in the societal condition. The court should also take into consideration development in science and technology. Reference to other statutes. One reference to statutes in pari materia. Pari means same, materia means subject matter. Hence, pari materia means the same subject matter. Statutes in pari materia would refer to the statutes on the same subject matter. Two statutes are said to be in pari materia when they deal with the same subject, person, or a thing. The rule of construction of statutes in pari materia means rule to the exposition of one act by the language of another act. According to Maxwell, light may be thrown on the meaning of a phrase in a statute by reference to a specific phrase in an earlier statute dealing with the same subject matter. Lord Mansfield states, when there are different statutes in pari materia made at different times or even expired, and not referring to each other, they shall be taken and construed together as one system and as explanatory of each other. Unless there is an indication of any change in the meaning as may be deduced from the purpose of the act, the words as used in the act deal with similar matters would be construed as having the same meaning. The statutes in pari materia can be lawfully referred to and determine the meaning of an ambiguous word. In other words, in order to resolve an ambiguity, help can be taken from other statutes also, provided that they are in pari materia, that is on the same subject matter. The meaning of an uncertain word cannot be imported from any other statute. Only the statute in pari materia can be legitimately called in aid. The rule of construction of statutes in pari materia may be called as a further extension of the basic principle of ex viceribus actus. According to ex viceribus actus, while interpreting any provision of a statute, the court is required to see that statute as a whole. The rule of pari materia permits to refer to the other statutes on the same subject matter. Previous legislation, assistance of an earlier statute. The legislature is the competent authority to enact the statutes on concerning subject to remove the mischiefs. Society changes from time to time. When society changes, the circumstances also change. If the change in circumstances required, the legislature may amend the existing act, and sometimes it brings a fresh act in place of the existing act. Sometimes courts, while interpreting the existing act, look towards the previous act for its interpretation, when the intention of the legislature is not changed. Assistance of later statutes help from subsequent legislation. There are conflicting opinions relating to assistance of subsequent statutes. One opinion is that it is not permissible to refer to a later statute for construction of an earlier statute. According to Coke, such an act should not be construed as any strained sense against the latter of the previous act. For of any exposition should be made against the direct letter of exposition made by Parliament, there will be no end of expounding. Incorporation of the earlier act into later. While law-making, legislature adopts a device of incorporation of an earlier act into the later act for the sake of convenience. In order to avoid verbatim reproduction of the provisions of the earlier act into the later, the legislature incorporates the required provisions of the earlier act or referred to in the later act and they form part parcel of the later act as if they had been bodily transposed into it. It is presumed that such incorporation is with all the amendments made in it till the date of incorporation. Constitution of Consolidated Statute. The primary rule of the construction of a consolidated act is to examine the language used in the act itself without any reference to the repealed statutes. It is only when the Consolidation Act gives no guidance as to its proper interpretation that it is permissible to refer to the repealed enactment for guidance, and it is never legitimate to have recourse to repealed enactment to make obscure or ambiguous that which is clear in the Consolidation Act. Codifying statutes. Codifying statute is a statute which presents an orderly, authoritative statement of the leading rules of law on a given subject. Switzerland states statute incorporation into a code is presumed to be incorporated without change, even though it is reworded, rephrased, and in the organization of the code in original sections are separated. Where, however, the legislative intent is clear that a change in law is intended, a new provision prevails. In case of ambiguity, it is permissible to resort to the prior legislative history of the Act, the form and language of the prior statute, prior interpretation, and all matters in pari materia in order to arrive at the true meaning of the code's provision. Foreign decisions. When the Indian statute practically reproduces the English enactment, it would not be proper to neglect the judicial decisions in England which have decided the proper construction of the section to be one thing and not the other. Contemporanea expositio, contemporanea exposition or construction. The word contemporanea means of the same time or period. Expositio means explanation. Rule contemporanea expositio is that interpreting a statute or any other document by referring to the exposition it has received from contemporary authority. In other words, the meaning attributed to the words of a statute at the time of passing of that statute shall be retained by those words even subsequently. Textbooks. The language of a statute is not precise and words employed therein are capable of bearing more than one meaning. Textbooks may be referred to resolve the ambiguity. However, the reference to textbook shall not bind the court in any manner. It shall be the discretion of the court either to accept or reject the meaning given in a textbook. What are the ways to resolve a conflict between parent legislation and subordinate legislation? Conflict between parent legislation act and subordinate legislation. The word conflict literally means inconsistency or repugnancy. Conflict is a situation in which one power tends to disregard another power, resulting in a clash or a conflict of interest between two individuals or two authorities. Subordinate legislation or delegated legislation is an act or legislation passed by virtue of authority conferred by the parent act or legislation. Hence, the provision of the subordinate legislation must be in consonance with the provisions of the parent act and should not surpass, supersede, override the parent act. In case any part of the subordinate legislation is directly or indirectly is in conflict with the parent act, it can be challenged on the ground that it is ultra-vires the parent act. The expression ultra-vires, ultra beyond vires power means beyond the power. The subordinate legislation should be passed by the subordinate authority within the powers conferred on it by the parent act. If the subordinate act is made impugning, violating, infringing the procedure laid down in the parent act, it is to be declared void, that is invalid. The conflict between the parent act legislation and subordinate legislation takes place under the following circumstances. When the subordinate legislation is passed, ultra-vires the power conferred on it by the parent act, when it supersedes or surpasses the parent act, when it contradicts the existing law in force, when it violates the provisions of the Constitution or a general law, when there is an excess delegation conferred, subordinate legislation conflict with the parent act. When the subordinate legislation did not adhere to the procedure prescribed laid down by the parent act, if the subordinate legislation offends against any of the mandatory provisions of the Constitution or the parent act, if the subordinate lawmaking authority wrongfully or unlawfully exercises its authority while enacting the subordinate legislation, when the subordinate lawmaking authority subdelegates its authority. Case law. Ram Prasad versus State of UP. In this case, the conflict arose between the Parent Act and subordinate legislation. Section 49 of the UP Panchayat Raj Act 1947. Parent Act prescribed the minimum numbers as a quorum to try, but the subordinate legislation provided for trial by a bench constituted under UP Panchayat Raj Act. It was held the subordinate legislation void and invalid on the ground it was in conflict with the Parent Act. In Banwarilal versus State of Bihar, AR 1961. Section 12 of the Mines Act 1952 made it obligatory on the central government to consult the mining board constituted under the Act before making rules thereunder. The framing of rules without consulting the mining board has been held as invalid by the Supreme Court because it was ultra-vires the procedure prescribed under Parent Act. Similarly, in Delhi Transport Undertaking versus BBL Hazari, the Supreme Court held that the rules framed under Delhi Corporation Act 1957 were ultra-vires the Parent Act. In the said Act, Section 90, Clause 1 of the Delhi Corporation Act 1957 designates the General Manager to be competent appointing authority of all persons drawing a salary less than 350 per month. Section 95 provided that no person shall be dismissed by any authority subordinate to the appointing authority. But the rules framed under the Act gave power to General Manager to delegate all his power to Assistant General Manager. This rule was struck down by Supreme Court as it was in conflict with Section 90 and 95 of the Parent Act. Cases. Grammatical interpretation. Sales of green ginger were subjected to sale tax, and it was contended that they were not so liable as they constituted vegetable, which were exempted from sale tax. The expression vegetable is not defined in the Act. Decide whether green ginger falls within the meaning of the term vegetable or not. Vegetables are exempted from levy of sale tax under Sale Tax Act. A vegetable vendor is selling betel leaves. He contends that the betel leaves fall within the scope of vegetables. Discuss. Sale Tax Act exempted vegetables from the levy of sale tax. Sales of betel leaves were subjected to sale tax by the authority. It was contended that betel leaves were not taxable as they constituted vegetables, which were exempted from tax. Besides, under the Sale Tax Act, vegetables were exempted from the purview of tax. A vendor of vegetables was selling coconuts. Tax authorities levied tax from the sale of coconuts. Vendor pleaded exemption on the ground that coconuts fell within the term vegetables. Can he succeed? Discuss. Sale Tax Act exempted green vegetables from assessment to sale tax. Sale of sugarcane was subjected to sale tax by authority. Question was whether sugarcane fell within the term of green vegetable. Decide. In the above stated cases, only green ginger comes under the vegetables and all the remaining, that is betel leaves, coconuts, sugarcane, do not come under vegetable. To decide whether a given item comes under vegetable or not is very simple. Here we should not go for the dictionary meaning or botanical meaning of that item. We should use simple common sense. Whether the item is used in our food frequently or not. If it is used frequently, then it becomes a vegetable issue. Whether green ginger, chili, lemon are vegetable or not. Yes, green ginger, chili, lemon are vegetable. Whether betel leaves, coconut, sugarcane are vegetables. No, they are not vegetables. Rule application. The act of sale of vegetable does not attract sale tax. Therefore, when a state sale tax officer wanted to tax the sale of betel leaf, vendor objected on the ground that betel leaf was a vegetable. He claimed exemption. To advance his argument, he relied on the dictionary meaning of the vegetable in the short Oxford Dictionary and textbooks on botany. This refers to the case of Ramavatar Buddhi Prasad versus Assistant Sale Tax Officer reported in 1961, which has become a landmark judgment by SC. The SC did not accept the scientific or dictionary meaning of the word vegetable and observed that it must be construed not in any technical sense nor from a botanical point of view, but as understood in common parlance. It held it has not been defined in the Act, and being a word of everyday use, it must be construed in popular sense, meaning that sense which people conversant with the subject matter with which the statute is dealing would attribute to it. It is to be understood as understood in common language. In this view, betel leaf was not a vegetable but a condiment. Not being a vegetable, it could enjoy exemption from sale tax. The judgment lays down the basic principle that a vegetable is one that in the market parlance is known as such. This distinction of vegetable for fiscal laws, but not so for student of botany, would regard betel leaf as a vegetable. So the definition depends upon who asks the question. For a botany student, betel leaf is a vegetable, but not so for a tax collector. Even after this definition is available, controversies arose on the so-called vegetables too, some of which traveled up to SC as coconut, green ginger, chili, lemon. Coconut was subject matter of SC decision in the case of P.A. Tellai Chidambar Nair versus State of Tamil Nadu, reported 1985. In this case, the Tamil Nadu General Sale Tax Act 1959, question was to whether a coconut, neither tender nor dried but a ripened one with or without husk, could be exempted from sale tax. Justice V.D. Tulsapurkar and Justice Ranganatha Mishra held it was well known that kernel of the coconut was used as an ingredient for enhancing states of food, but was hardly used as a substantial article of food on the table. On this ground, they held it was not a vegetable. However, Justice Sabyasachi Mukherjee observed that it could not be categorically said that ripened coconut could never be considered as a vegetable. However, the SSC could not adduce enough evidence to prove it. He gave the legal verdict that the burden of proof that coconut was a vegetable was on the person who claimed it to be so, and since he was not able to discharge the burden of proof, it could not be regarded as a vegetable in law. On this basis, the SC finally decided that ripened coconut was not a vegetable. Chili and lemon were subject matter of decision by the SC in the case of Mangulu Sahu Ramahari Sahu versus Sale Tax Officer Ganjam Orissa, 1974. In this case, under the Orissa Sale Tax Act, the question was whether chilies and lemons are vegetables. HC held that they were not vegetables. It had gone on the basis that there is an item that considered a vegetable. It had to be a principal item of food. It also considered the botanical meaning of the word. SC observed that technical botanical meaning should not be considered for tax purposes. So while HC said they were not vegetables, Supreme Court said they were. Green ginger came up for a decision before Supreme Court in the state of West Bengal versus Wasi Ahmad, reported in 1977. In a case under the Bengal Finance Sale Tax Act, the issue was whether green ginger was to be regarded as a vegetable as obtained in the description vegetable green dried commonly known as sabzi, tarkari or saag. If it was treated so, it was exempt from sale tax. The SC relied on the fact that in common parlance, green ginger was known as a vegetable. It was grown in the kitchen garden or in a farm and was used for the table. It did not accept the view of sale tax tribunal that it was a flavor. Conclusion. When an item is used frequently, it comes under the category of vegetables, and items like betel leaves, sugarcane, coconut are not come under vegetables because they are not used widely in our kitchen. We should not go for a dictionary or botanical meaning of the item, but usage decides whether the item qualifies to be called vegetable or not. The Passers-by Mischief Rule of Interpretation, Smith versus Hughes. The Street Offences Act was passed by the legislature prohibiting solicitation by prostitutes at public places. Thereafter, prostitutes solicited from balconies or windows of their houses. Does it amount to street offence? What type of interpretation is preferable? Discuss. Soliciting in the street for the purpose of prostitution is an offence punishable under the Street Offences Act. A woman is making signs to men as they pass in the street from a window. Is it a street offence? Which rule of interpretation can be used in this case? Mischief rule. Whether the act of soliciting from balconies by a prostitute is illegal? Yes. Rule. Section 1 of State Offences Act 1959. It is an offence for a prostitute to solicit men in a street or a public place. Application. The above given case is similar to the case of Smith versus Hughes, and the interpretation should be done by applying mischief rule. Smith versus Hughes under the Street Offences Act 1959, it was a crime for the prostitute to solicit in the street for the purpose of prostitution. It includes all the acts to attract them. In this case, the prostitutes were calling men in the street from their balconies by making signs to them. The prostitutes claim that they are not guilty of an offence because they are not doing this act of soliciting from streets. Judge applied mischief rule to conclude that they were guilty as the intention of the act was to cover the mischief of harassment from prostitutes. The overall case was to deal with cleaning up the street for people to walk along the streets without being molested or solicited by prostitutes. The prostitute would be penalized and arrested would be found guilty of the offence if they were to be soliciting in the streets. In this case, the question was whether a woman who had tapped on the balcony and hissed at men passing by was guilty of an offence under the Act. Parker found her guilty. He says, I approach the matter by considering what the mischief is aimed at by this act. Everybody knows that this was an act. In the given case, the act of prostitute soliciting men is illegal, even though the prostitute soliciting from balcony or windows by using mischief rule. The intent of the legislature is to stop the prostitutes from attracting the men. The act of prostitutes from their balconies also comes under this section and hence illegal. Next case, whether a student is a consumer or not. A term consumer is defined under Consumer Protection Act. However, problems arose as to whether a student falls within the meaning of the expression consumer. In such a case, what type of interpretation is preferable? Discuss. Issue, whether a student is a consumer or not, it depends on the services. Consumer Protection Act 1986. The Consumer Protection Act 1986 in this respect was sufficient to fulfill the requirement of every consumer by providing various reliefs available in the Act. In India, diverse groups of consumers are available. The consumer protection law protects the interest of every consumer irrespective of the age, sex, caste, place. With respect to all kinds of goods defined under the Sale of Goods Act 1930 and every kind of services possible to be contemplated as service under the Act 1986. This Act extends protection against government body, statutory institution as well as corporate sector. The most pragmatic feature of this Act is the recognition of a consumer's right to be informed about the quality, purity, standard and price of goods and services, which is a potential device to prevent exploitation. Concept of service and consumer under the Act 1986. The term service is defined as Section 210 of 1986 Act. Service of any description which is made available to potential users, including the provision of facilities in connection with banking, financing, insurance, transport, processing, supply of electrical, other energy, board or lodging or both, housing, construction, entertainment, amusement or purveying of news or other information, but does not include the rendering of any service free of charge under a contract of personal service. Therefore, it is clear that the preamble of the definition of the service of any kind or nature that is rendered in exchange of consideration to direct the potential consumer comes within the definition of service. Some types of services even enumerated in an explicit manner within the definition, but the definition of service is not limited to only those mentioned explicitly. Medical service is not included directly. However, a series of judgments are available that identify medical treatment and facility associated therewith is classifiable as a service under the Consumer Protection Act. The term consumer as per Section 21D of the 86 Act includes any person who buys any goods for consideration or avails any service for consideration. Therefore, the term consumer is really broad and includes any beneficiary of service without differentiation with respect to the type of beneficiary or nature of goods or service he or she purchases. Interestingly, the scope of service in this definition also has no limit because of the term any service. Therefore, there is no bar in accommodating students into the definition of the consumer because any person connected as the purchaser to any goods or services is the consumer as per the Act. It is still important to find support outside the Consumer Protection Act in favor of the term consumer when it applies to the student in the affair of university-student relationship application. Do educational institutions fall under the purview of the Act? A considerable number of decisions delivered by the state and national level consumer forums are available as of now which protect the right of students with regard to fees, wrong allotment of roll number, delay in declaration of results, admission in excess of allotted quota, misrepresentation about affiliation. A considerable number of decisions delivered by the state and national level consumer forums are available as of now, which protect the right of students with regard to fees, wrong allotment of roll numbers, delay in declaration of results, admission in excess of the allotted quota. Misrepresentation about affiliation by the educational institute to various universities. The judgments related to the above-mentioned cases clearly indicate the student is a consumer as per the Act, and the universities or educational institutes fall within the category of service providers. But the Supreme Court of India has a differing view. In the case of Maharshi Dayananda University versus Sujit Kaur, relying upon all earlier judgments, Supreme Court held that education is not a commodity. Education institutes are not providing any kind of service. Therefore, in the matter of admission fees, there cannot be a question of deficiency of service. Such matters cannot be entertained by the Consumer Forum under Consumer Protection Act 86. Further, Honorable Supreme Court in Bihar School Exam Board versus Suresh Prasad Sinha, Supreme Court observed that the educational boards and universities are not service providers and a complaint against them are not maintainable. On the other hand, it is also necessary to assess the definition of the consumer under Section 21D of the Act to check that the relationship between the university and the student fits with the conventional relationship of a trader or a service provider and consumer. If these two criteria are satisfied, then it can be said the university's educational institute come within the ambit of the consumer protection law. Assessment of activities of university or educational institute. The functions of university education institute can be divided into two main categories. Core function of the university education institution, which is imparting education and advanced knowledge by providing instructional research facilities to educate and train manpower for the development of the country for welfare of the people, their intellectual, academic and cultural development. Here the core functions and activities associated with it are inseparable, and this is the statutory duty of the university and educational institutions as defined in the Central University Act. Secondary or ancillary services like providing hostel and accommodation facility, auditorium, library, laboratory, gymnasium, canteen, transport service to and from campus, internet service. In addition to the above, the university supplies various goods to students like textbooks, study material, notes, video CD, other electronic material including software programs. The ancillary services provided by the university undoubtedly fall within the category of those services and provision of goods as per the Act. The hostel or accommodation facility falls within the scope. The meaning of the board and lodging transport facility provided to the student is also within the scope of service. The foods and beverages provided to the student through canteen facility, laboratory equipment, video CD, software program obviously come within the purview of goods as per the Act. Commercial activities like consultancy, transfer of technology to the company through the patent right and thereby enjoying royalty, handling private projects, entrepreneurship incubation are some of the commercial activities performed by the university's educational institutes in order to earn the profit. It is clearly reflected from Central University Act that university may enter into partnership with industry and non-governmental agencies and establish a corpus fund out of the profits of such partnership. The Honorable Supreme Court in Bangalore Water Supply and Sewerage Board versus Rajappa has considered among other things that education institutes are classified as industry as defined in Section 2J of the Industrial Dispute Act while determining the import of the aforesaid term. Reference to words like service, business, profit, industry, partnership is available within the Central University Act itself, which clearly proves that university is not a non-profit body, rather than it has some business characteristics inherent in the statutes and acts which govern the function of the university. Critical analysis of the university-student relationship in the context of consumer protection. The students enjoy all kinds of facilities, that is, both core and ancillary services rendered by the university or educational institute after paying the requisite fees. Therefore, the students are direct beneficiaries and consumers of the service rendered by the university. A student, after paying the requisite tuition fees, deserves a good quality education. Critical analysis of university-student relationship in the context of consumer protection. Students enjoy all kinds of facilities like core and ancillary services rendered by the university or educational institute after paying the requisite fees. Therefore, the students are direct beneficiaries and consumers of the services rendered by the university. A student, after paying the requisite fees, deserves a good quality education and facilities related thereto. Similarly, after accepting remuneration, it should be the moral duty and obligation for a teacher and university to provide adequate service in terms of good quality education. If the teacher or university fails to comply with this requirement, then it amounts to deficiency in service because universities and institutes are imparting education in exchange for consideration. But it is also necessary to understand that the relationship between student and university is not an ordinary relation of a buyer and seller in the true sense. The statutory duty of the university is fixed by certain acts, rules, and regulations. A student, only after complying with the requirements fixed by the university in terms of its rules and regulations, can claim his or her entitlement as a consumer service rendered by the university under Act 1986. In my opinion, the teacher-student relationship should not be the only deciding factor to decide whether the various facilities provided by the University Educational Institute should fall under the term service as per Act 86. Because the teacher-student relationship is totally subjective, which will vary depending upon the character of an individual teacher. In this respect, three court decisions are available and those contradicting to each other. In Taneja versus Calcutta District Forum, it is held by Calcutta High Court. The relationship between teacher and student in an education institute is not one of service provider and consumer. Same principle was almost followed in Central Academy Education Society versus Gaurav Kumar, where it was held by the court that teaching is not capable of marketization as opposed to the sale of books and provision of accommodation. It is marketable and can be considered as a service as per Act. Whereas in Oza Nirav Kanubhai versus Central Head Apple Industries, the National Commission held that private educational institutes, that is, institutes that are not statutorily established to be classified as service providers, and students enrolled therein and their sponsors as consumers. Therefore, the student-university relationship, although not equivalent to a relation of a consumer and service provider in the strict sense, but complaints against the university educational institute are maintainable in consumer court on the ground that student is nothing but a consumer as long as the complaint is genuine. Student is a direct beneficiary, in other words, consumer of the service rendered by the university and is supported by the fact that provision for student engagement in academic activity of the university, including evaluation of a teacher, is available in Central University Act 2009, which implies that the student is nothing but a direct consumer of educational service. Right of a student and responsibility of university. It is imperative to understand the various rights or entitlement of students under University Education Institute, in the absence of which the noble mission and object of the university get defeated. The important rights of the student, which are very essential to protect the interest of every student in the field of education, are mentioned below. Right to receive a good quality education, right to receive all benefits, services related to study like laboratory, library, good quality study material, right to get proper and correct information related to terms and conditions of university, disclosure of fees, affiliation, quality standard, facilities available in university, right against exploitation of any kind in the university, right to care regarding safety and protection from injury on the campus, the right to a grievance filing procedure. It is the responsibility of the University Education Institute to safeguard the rights of the student in order to fulfill the noble objects as enshrined in the Statutes and Act of University. There are various provisions in Central University Act which empower the university to frame rules, guidelines, ordinances with respect to the condition of residents and students to provide good quality accommodation, the condition of residents and teaching of women students, specialized laboratory, maintenance of discipline in order to prevent ragging and safety of students, redressal of grievances, right to appeal against the arbitrary action of any officer or authority of the university in order to safeguard the interest and betterment of the student. However, there are lacunae in the Act with respect to two factors: absence of redressal mechanism at the individual student level and no direct remedy available for the university if found deficient in providing service or accused unfair trade practice. Support available in case laws in favor of student as consumer. Following court decisions have been quoted to substantiate the argument that student as a consumer university is a service provider. Jai Kumar Mittal versus Brilliant Tutorials. In this case, it was held that supply of defective study material by an institute can sustain a valid claim against for deficiency of service. In Bhupesh Khurana versus Vishwa Buddha Parishad, due to misrepresentation about affiliation, National Commission held, in respect of the recovery of the fees paid to the institute, that the institute was liable to refund the fees, having lured the student to enroll it through the deceitful tactics. Birla Institute of Technology and Science, Abhishek versus Abhishek Mengi. National Commission observed the forfeiture of fees by the educational institute without imparting education amount to unfair trade practice. Sonal Matapurkar versus S. Niglingappa Institute. In this case, the admissions were made by the Central Institute over and above the sanctioned fees, as a result of which students were not allowed to appear in the exam by the university. Since students had paid huge donation and also made an investment of time and energy, National Commission held that there was deficiency in service and complainants were entitled to refund of the donation and compensation with interest and cost. Secretary Board School Education, Haryana versus Mukesh Chand Pawalwal. In this case, the respondents declared the results after a period of 1 year and 8 months of the scheduled time. Haryana State Commission held there was erratic functioning in the part of the opposite party. It had a callous attitude towards students, which is the deficiency in service on its part. Therefore, the court decision cited above clearly accepts the student is a consumer of service provided by the university, although many judgments are also available where this consumer and service provider relationship is vehemently denied. Critical analysis of three decisions delivered by the Honorable Supreme Court to restrict the scope of Consumer Protection Act with respect to educational activity. Bihar School Examination Board versus Suresh Prasad Sinha. The issue was raised regarding the issuance of the same roll number to three different candidates by Bihar Board of Secondary Education and failure to declare the result of one of the candidates. In this case, it is held by the Honorable Supreme Court that the Consumer Protection Act is not applicable with respect to statutory function of statutory bodies. However, the board is a statutory body and conducting the examination is in exercise of the discharge of statutory function. Therefore, in this case, the Bihar Board of Secondary Education is not providing any service. The examination fee paid by the candidate is also not considered as a consideration. It is true that conducting an examination is not a marketable service. However, findings in the case of functions performed by the statutory bodies outside the scope of service under Act 86 is not supported by earlier Supreme Court decision, the Lucknow Development Authority versus M.K. Gupta, where Supreme Court held that the activity of the statutory body is not exempt from the deficiency of service as per Act 1986. Again, the Honorable Supreme Court in Bangalore Water Supply Sewerage Board versus Rajappa had considered, among other things, that educational institutes are classified as industry under 2J of the Industrial Dispute Act while determining the import of the above mentioned item. Therefore, when there is negligence in performing the statutory duty, it should not be exempted from purview of the consumer law. When students pay the examination fee, then he or she is entitled to get correct roll number, admit card, question paper for writing exam, answer, the chance of scrutiny or review of the answer sheet being a candidate of examination, other facility provided by the examination board to every student. If there is a deficiency in the processing of the registration number, roll number, admit card, allotment of examination center, amounts to deficiency in service on the part of the examination board because equal opportunity is the right of every candidate appearing in the exam. Maharishi Dayanand University versus Sujit Kaur. In this case, the student had enrolled in two courses simultaneously, one full-time course and one correspondence course. Such enrollment being in contravention of the rules, the university directed her to unenroll from one of the courses, pursuant to which she unenrolled from the correspondence course. However, she participated in the supplementary exam in respect to the correspondence course, despite having cancelled her enrollment therein and passed it. However, he having taken the exam for correspondence being in contravention of the university rules, the university refused to confer the degree on her. University has the statutory power to enact laws, make ordinances in respect of functioning of the university. If any action taken by the student in contravention to the existing rules and regulation of the university enforced at the time of action, then the student is liable to face the consequences as per existing rules. In those circumstances, student cannot claim relief available in the Act of 1986 as a consumer of service. It should be borne in mind that the statutory laws of the university and rights provided in the consumer law should not contradict each other. Statutory laws of the university and consumer protection law both are enacted in order to make the functional activity of the university effective. At the same time, to protect the right and interest of the student safe. So these two laws should reinforce each other to protect the interest of both student and university. P.T. Koshi versus Ellen Charitable Trust. Supreme Court held in a brief order that educational institutes do not, through the performance of educational activities, render any service, in respect of which a complaint of deficiency could be maintained. That consumer forums did not have the jurisdiction to educate the same. In view of the above discussion and explanation, it is found that in order in the matter of P.T. Koshi, it does not have a support of legal or logical grounds. Conclusion. In view of the above discussion, it is proved that with regard to the application of the Consumer Protection Act is justified in case of educational activity or service rendered by the university. It is supported equally well on legal and logical grounds. Students are direct consumer or beneficiary of the service and facility provided by the university. All kinds of activities performed by university education institute may not be classified as marketable service because of the nature of those particular services. But it does not support the complete exclusion of the university from the scope of the consumer protection laws. At the same time, students should not get the opportunity to get any undue privilege in contravention of the existing rules and regulations specifically mentioned in the statute and acts of the university with illegitimate demands as a consumer of service. Therefore, in conclusion, university education should come within the ambit of consumer protection law as long as the complaint is genuine on the ground that the legal right or interest of the student is prejudiced due to inefficient or deficient service or unethical trade practice by the university or education institute. Rule of strict construction of the penal statute, Tolaram versus State of Bombay, Section 82-83 IPC. A provision of penal statute is capable of two possible interpretations. One interpretation leads to conviction of the accused and the other interpretation leads to acquittal. Which interpretation has to be preferred? Give reasons. Issue: which rule of interpretation is applicable in this case? The strict rule of interpretation, because it is a penal statute. Rule: the rule is stated by Mahajan Tolaram in versus State of Bombay is that if two possible and reasonable constructions can be put upon a penal provision, the court must lean toward that construction which exempts the subject from penalty rather than the one which imposes a penalty. It is not competent for the court to stretch the meaning of an expression used by the legislature in order to carry out the intention of the legislature. In the state of Jharkhand versus Ambe Cement, Supreme Court held that it is settled rule of interpretation that where a statute is a penal in character, it must be strictly construed and followed. Application: the basic rule of strict construction of penal statute is that a person cannot be penalized without a clear letter of law. Presumption or assumption has no role in interpretation of penal statute. They are to be construed strictly in accordance with the provisions of law. Nothing can be implied. In such cases, the courts are not so much concerned with what might possibly have been intended. Instead, they are concerned with what was actually said. In criminal cases, the strict construction is a general rule of construction. If the penal section covers only some cases of persons, their essence cannot be extended to cover other persons. Section 82 of IPC deals with an act done by a child below 7 years of age, exempt them from all criminal liability. 83 deals with act of children who are above 7 but below 12. Two sections make no provisions for an infant who is of exact 7 years. It is submitted that such an infant should be dealt with under 82 of the code because penal statutes are to be interpreted strictly. In order to warrant a conviction for an offence, a case must fall within the ambit of the definition of the offence charged, and the rule is that the benefit of all reasonable doubts must always go to the accused. Conclusion: the given case pertains to the penal statute, and penal statutes are to be constructed strictly. According to Lord Esher, if there is a reasonable interpretation which will avoid the penalty in any particular case, we must adopt that construction. If there are two reasonable constructions, we must give more lenient one. Accused is given case ineligible to get a lenient approach and should not be punished. Consequences of repeal. Effect of repeal. A law was enacted by the legislature in the year of 2009. X was challenged for committing an offence punishable under the said Act in 2012. When the trial against X is pending, Act of 2009 is repealed under year 2013. What is the effect on the trial of X? Discussed. The Prohibition Act was enacted by the state legislature under the sale, possession, transportation, and consumption of liquor was an offence. Mr. X has committed an offence punishable under the Act when the Act was in force. Later, the said Act was repealed by the same legislature. X charge sheeted after repeal of the Act. Is it legal? Discuss. X was charged for committing an offence punishable under Prevention of Terrorism Act. When the trial was pending, the said Act was repealed by the Parliament. Was it its effect on the pending trial? Issue: is the legislature having the right to repeal an act? Yes. Can the trial of the accused be continued after repeal of the act? No. Prosecution of the case will come to an end. Rule: is the legislature having a right to repeal an act? Yes. Can trial of the accused be continued after repeal of the act? No. Prosecution of the case will come to an end. Rule: పర్లేదు మేము పట్టుకెళ్తాను. నువ్వు వెళ్ళాలంటే నువ్వు వెళ్ళు, మేము పట్టుకెళ్తాను. వదిలే కూర్చొని. ఎందుకంటే కాసేపు చదివి వినిపిస్తుంది, ఏదో ఒక యాక్టివిటీ చేస్తే ఏదో చెప్తుంది. నువ్వు అవి చేయించవే. చూడమని వెళ్ళి చూడమని ఏమన్నా చూడమని. మీరు చూసి చెప్పండి ఏమున్నాయో. ప్రీవియస్ లా మే బి రిపీట్. చూడు, నీ మనసులో ఉన్నది మీ అత్తగారు కనిపెట్టేసింది. ప్రీవియస్ లా మే బి రిపీల్డ్ either expressly or by implication. In both cases, the consequences are the same. Following are the effect of the repeal or enactment, Section 6 of the General Clauses Act 1897. Latter Act abrogates the prior one. Repealed Act ceases to exist and does not remain in force with effect from the date of repeal. As per general law, except in relation to the past and closed transaction, a statute after repeal is completely obliterated, as if it had never been enacted. When an act is repealed, all laws passed under it stand repealed, unless there is a saving provision. No proceedings can be commenced or continued under an act after its repeal. However, those cases remain unaffected by such repeal in which proceedings have been brought to finality before repeal of the statute. Application: the state of Uttar Pradesh versus Jagmohan Das, 1954. The apex court held that when a statute is repealed or comes to an automatic end by effect of time. No prosecution for the act done during the continuance of the repealed expired act can be commenced after the date of its repeal or expiry because that would amount to enforcement at repeal or a dead act. In Gajraj Singh vs. State Transport Appellate Tribunal, Supreme Court has held that when an act is repealed, it must be considered except as to the transactions past and closed, as if it had never existed. The effect thereof is to obliterate the act completely from the record of the Parliament as if it had never been passed. If never existed except for the purpose of those actions which were commenced, prosecuted, concluded while it was an existing law. Conclusion. In the given case, the prosecution against Mr. X cannot be continued because the act under which charges are framed are repealed before his case is finished. Hence, the prosecution will come to an end and Mr. X is free from all earlier charges. Repeal and reenactment. Section 24 of the General Clauses Act 1897. A Control Act was repealed and reenacted without modification. What is the effect on the orders and rules made under the repealed act? A Central Act was repealed and reenacted without modification. What is its effect on the orders and rules made under the repealed act? నువ్వు ముందు కూర్చోవే, వెనక్కి కూర్చుంటే ఆవిడకి కాలక్షేపం అట్లా.
చాలా లోతైన బురద ఉంటారు.
చెప్పండి చెప్పండి. మంచి
లోపల కూరుకొని పోతే బయటికి రారు అంటారు. దాన్ని ఏమంటారు? బురద ఉండి లోపల కూరుకొని పోతే బయటికి రారు.
ఊ అంటారు. ఊ తర్వాత ఊబి. ఊబి
మరి
made under the repealed act are still in force after reenactment of the act. Yes. Section 24 in the General Clauses Act 1897 continues. Issued under enactment, repealed and enacted. Where any central act or regulation is after commencement of this act repealed, reenacted with or without modification, then unless it is otherwise expressly provided, any appointment, notification, order, scheme, rule, form, bylaw made and issued under repealed act or regulation shall, so far as it is not inconsistent with the provisions reenacted, continue in force and be deemed to have been made or issued under the provisions so reenacted, unless and until it is superseded by any appointment, notification, order, scheme, rule, form, bylaw made or issued under provisions so reenacted, and when any central act or regulation which by notification under Section 5(5)(a) of the Second Scheduled District Act 1874 or any like law has been extended to any local area, has by subsequent notification been withdrawn from the re-extended to such area or any part thereof, the provisions of such act or regulation shall be deemed to have been repealed and reenacted in such area or a part within the meaning of this section. Application. Conclusion. So when it is reenacted, everything will re-extended to such area. All the orders and actions that are taken will continue. Next, inconsistency between substantive law and procedural law which will prevail. If there is inconsistency between a provision of a substantive law and a provision of the procedural law, which shall prevail over the other? Discuss.